we inspected various health centers, my lord. So that report has come, my lord. Since it is voluminous and separately we'll have to file the all report in all the cases. So therefore we require some more time, my lord. 3 weeks time may be granted.
What kind of inspection report?
My lord, inspection report, my lord, there was a direction from this honorable court an earlier occasion to conduct the inspection as per the allegation. Whether the allegation, as per the allegation projects in the PL, it is true or it is not. So that can be only ascertained by physical verification, inspection. So accordingly, committee was constituted and we conducted the inspection at the various institutions which involved in the litigation, madam. So that report has come. We'll bring it on record, madam.
What have you found in the inspection?
Inspection, my lord.
Inspection.
My lord, during inspection, my lord, of course, some of the allegation, my lord, the infrastructure, my lord.
Let us take one PHC for instance.
My lord.
Yes.
My lord,
Deficiency in all the PHC cannot be the same.
my lord, not same, my lord.
Let us take one PHC. Which PHC you would like to take up?
My lord, there's certainly.
See, I wonder how this PL can be closed.
My lord, my lord.
And I find no endeavor has been made to close this PIL.
My lord.
It is of 2019 matter. Allegation is a deficiency of infrastructure, manpower,
Yes.
Yes,
my lord.
equipments in PHCs. And in short, not conforming to somewhat Indian public health.
Public health, yes, is standard.
Isn't it?
Yes, my lord. So, in that case, my lord,
Now, how you propose to close this PIL?
my lord, only as my lord has also earlier occasion, my lord, to point out.
Nobody is making an endeavor to close this PIL.
My lord, last occasion.
Yes.
Last occasion, my lord, I insisted, and then even my lord has some opinion that this can be disposed of, directing the authority, like wherever there's a deficiency, that the government shall make an endeavor to rectify those things and make available, madam, what is possible in the department, my lord.
I think that can be done after this inspection.
That was, my lord, the earlier occasion also we had, my lord, raised this point, my lord, for disposal, my lord. Otherwise,
You tell us one finding of the inspection team. Yeah. If nobody makes an effort to dispose of this
No, in fact,
PIL,
as a petitioner, in fact,
this will continue to be repeatedly listed
in this PL, our concern.
without any fruitful and consequential orders.
In fact, the petitioner, especially in this PL, concern is that the
Suppose in particular PHC,
my lord.
D sector has a PHC.
it should be a Chimpu.
Okay, let us
Chimpu,
take Chimpu.
Itaport, Chimpu is there, my lord.
If there is no, say, ambulance,
Yes, ma'am.
is there an ambulance
My lord is there.
in Chimpu?
Yes.
Required number of ambulances there.
Well, it's there, my lord.
Required number of doctors,
Yes.
medical staff is there.
My lord, my lord.
Then what is the deficiency there?
My lord, only deficiency they are saying is that there's no equipment, there's no proper labor room. That's part, my lord.
No equipment.
My lord. As per their allegation, my lord.
According to the inspection team report, there are
My lord, as per the inspection, my lord,
there are equipments, there are labor rooms.
my lord, it fulfills, my lord. But some part, my lord, some PHC, my lord, it requires some further improvement, my lord. That is there, some finding remarks there, my lord. Otherwise, some of this all fulfilled, my lord. So, my friend, my lord.
And I don't think this PL can be heard together. It has to be heard individually.
Exactly.
Each case pertains to particular PHC.
Yes, sir.
And the deficiency is not similar.
Yes,
Yes.
if both of you cooperate, we can dispose it entire matter by a short order.
My lord,
Which will be beneficial also. But nobody seems to be interested in disposing of this PI. When? Tomorrow, day after tomorrow.
my lord, next week, can it be possible next week, my lord?
Yes. When you will file, within 2
Uh,
days you file it. Inspection report.
my lord, within this week, I'll try my best, my lord.
The report is already with you.
Yes, my lord, because that is in clumsy, my lord, it's voluminous, my lord. That's why we'll have to extract various the center, my lord, for convenient, my lord.
So we list it on Monday. Next.
My lord,
They have to file and they have to supply to us also.
my lord, that's we'll do it, my
If
lord.
we have no intention to close this PI, we'll keep it pending, Mr.
No, in
Mr.
fact,
Mao.
it is not the
And-
issue, my lord.
And see, since 2019, you're not getting any favorable order from this court. We are trying to pass favorable order.
No, we are seeking favorable order from your honorable court, my lord. That's how the inspection has been, direction is for the inspection. Because they were not filing the correct replies.
My lord, that is not
That's
a
how the your honorable court was pleased to direct for the inspection. So that if there is deficiency, they
my
can
lord,
do some more improvement in that area. In fact, disposal, in fact, it can be monitored by your honorable court because concern is the health issues.
Do you expect this court to run the health administration?
I mean, obviously, it is part of the right to life. It is a constitutional matter. It can be monitored by the honorable court.
my lord, there was a certain
If there
occasion,
is
various
deficiency in
occasion,
that.
my lord, this honorable court has been, my lord, insist of for disposing, my lord. This is the petitioner who has not interested in disposing. my
Right to
lord.
health is a part of right to life. So it can be monitored by honorable court as a being a constitutional body. Because our intention is that whether they file inspection or
Right
not
to-
file, but
right-
the thing is that the health center should function with all facilities, with the
Right
main
to-
power, that is the only issue.
Right to education is also part of a right to life.
Yes, this also become a fundamental right.
Right to environment, right to clean environment is also a fundamental right, Article 21. Correct? You want this court to monitor the functioning of the Department of Environment and Forest?
Well,
You want this court to monitor the administration of the Education Department under the garb of Article 21?
Well, it is discretion to your honorable court, my lord. But my prayer is always remain like pray for the relief or what we are praying in the PIL. It's a discretion to your honorable court. If it can be a disposal with good direction, then no issue, my lord. So because we are seeking only a good directions and they make sure that the health center is functioning. That is the only issue here. So it is discretion of your honorable court. This matter can be disposed.
Mr. S. Mao, London Counsel for the petitioners, and Mr. E. Kalum, London Standing Counsel for the Health Department, who submits that he may be granted 1 week, 1 week time to file. A report of.
Yeah, inspection, but to bring on record inspection report,
He may be granted 1 week time to file the
inspection report.
inspection report. As directed by, which has been conducted
By the committee, my lord.
by the committee constituted in terms of the order passed.
Yes,
by the
yes, ma'am.
court earlier. Also. Mr. Mao, London Counsel for the petitioners, has submitted that after the after the inspection report is filed by the health department, he will he will have to go through the report of the inspection report file, for which he prays for listing of this matter after 6 weeks. Let's pray for 6 weeks.
No, my lord, it may be listed up to 2 weeks, my lord. 6 will be too late. Or date may be fixed if can be disposed of, that's no issue.
How much time you will require to go through the inspection? Team?
At least 2 weeks maybe.
Okay, for which, he plays for 2 weeks time. Maybe consider the nature of prayer made. List this matter after 6 weeks. If you are interested for disposal of the case, we are ready to take it up in the next week also.
No, it can be taken up next week. No issue, man.
6 weeks. Right. But without your assistance, we can't dispose of this matter.
No, I'm ready, my lad. But the thing is that I'm not saying that I will not be ready.
We'll see after 6 weeks. We'll thereafter genuinely make an endeavor to dispose of the PI.
Then, my lad, date may be fixed. Then
No,
it's not.
there can't be any 6 weeks. Yes.
they will be happy. The more they are thinking, they are happy, my lad. Especially other sites.
You want the matter to be taken up on Tuesday?
Tuesday, in fact, this is a
Tuesday.
my lad,
25, madam. 25.
Yes, 25, you'll be ready on 25th? Yes, next. Yes.
Last, may I please mention item 38?
Hmm?
Item number 38,
38.
38. Here, parties are negotiating for out-of-court settlement. Therefore, this matter may be listed after 4 weeks, madam.
Okay, on the prayer of Mr. G. Lally, council for the, I'll appeal and list it after 4 weeks.
After 4 weeks. Most of it.
May I please, Your Lordship? Your Lordship, I beg to mention item number 8, Your Lordship. Mr. Arsoikia is the leading counsel and he is out of station, Your Lordship. I have taken the consent of the respondent side also, Your Lordship.
Yes.
After 3 weeks, Your Lordship.
Okay, item 8 of the 3 weeks.
Highly available.
My lord, I would like to mention item number 5.
Right. Yes.
I'm on behalf of T. Tabu, leading counsel for the petitioner is from Delhi, and respondent are yet to file the affidavit. So matter will be listed after 3 weeks.
Okay, 3 weeks after 3 weeks. All right.
Your Lordship, may I mention item number 37? It may be listed on next week. 37.
37.
Yes.
Next week.
Next week.
Okay, after the week,
A week.
37. Number 1.
My lord, leading counsel is out of session for medical ground. My lord, and we don't want to file rejoinder in this matter.
Huh? You want to file regional also?
We don't want
Okay, don't want to. Your senior is out of the station.
out of session.
But in that case, my lord, if it is not inconvenient, since your lordship has fixed the yesterday's matter on 7th, can this also be on 7th? Since I'll be coming anyway.
Yes.
So, this problem. 7th. Yeah. In that case, let it be 21st.
21st. 21st is what day?
It's a Monday. Or if your lordship deems it appropriate, it can be on 22nd also. These 2 days are.
When?
My lord, I was playing, I'm
21st, 2022 is?
He has been instructed to fix it on 15.
15.
I just pointed out that it's a holiday.
15 August.
15 or 16.
15 or 16.
Yes, ma'am. 15 is holiday.
So we fix it on 15?
My lord,
Let it be on 21st. That week, 14 onwards, that week I have a little
No,
difficult.
21st of July,
21st of August.
August. So 21st.
Okay, madam.
Okay. This is on 21st of August.
Obligation.
Yes, my lord. Affidavit, my lord, I have received, my lord, from respondent, my lord.
Hmm.
Here, my lord, issue, my lord, involved, my lord, I am praying, my lord, framing of rule, my lord, to implement the, my lord, this Arunachal Pradesh Freedom of Religion Act 1978, my lord.
Hmm.
I am saying, my lord, as this is mandate of law, legislation, my lord. Executive, my lord, need to implement, my lord, this, my lord. Now,
Frame rules.
yes, my lord, they have yet to frame the rule, my lord, in terms of this act, my lord. So in absence of rule, my lord, this legislation, my lord, cannot be get implemented, my lord. That's why I am framing, my lord, praying for, my lord, framing of rule, my lord.
What is this? What is
Basically,
this?
my lord, this law, my lord, this law, my lord, was, my lord, legislated by the legislation, my lord, in 1978, my lord, particularly to, my lord, safeguard the, my lord, paid culture, religion, ritual of this, my lord, indigenous people of the state of Arunachal Pradesh, my lord.
Hmm.
Now, if my lord kindly turn to my lord status, my lord, I have, my lord, through annexation, my lord, I have tried to indicate, my lord, how, my lord, non-implementation of this legislation, my lord, is affecting, my lord, our indigenous page, my lord. Page number 24, my lord, 24 2 series, my lord. Now, status, my lord, if my lord kindly page 25, my lord. 20 last occasion, my lord, I failed to indicate this whole thing, my lord. Page number 25, my lord, Arunachal Pradesh, my lord.
Yes.
Last row, my lord, we'll see, my lord. This is the last row, my lord. Indigenous faith are classified under, my lord, other religion and persuasion, my lord. We were, my lord, in 1981 census, my lord, we were 51.60. Sorry, my lord, 71, down below 71, my lord, we were 63.46, my lord. Now in 1981 census, we become these people become 51.60, my lord. Now next page, my lord. Next page, my lord. This is of 91, so 81, 91, my lord, will see, my lord.
No, what have you shown from page 25?
25, my lord, is the position, my lord, population, my lord, population ratio of the, my lord, indigenous faith believer, my lord. At that point of time, my lord, in 1971, my lord, these people, my lord, the indigenous people, 83.46% of the population, my lord. Last row, my lord, last row, my lord, this is in ratio, my lord. Arunachal Pradesh, my lord, there is census is 1981 and 71, my lord. 71, this is 63.46, my lord. Now 81, it became 51.60, my lord. Decreasing, my lord. 81, my lord. Similarly, my lord, in 1991 census, my lord, that I also
No, I have not been able to follow page 25.
25, my lord. If my lord, row 1 is, my lord is Arunachal Pradesh, my lord.
Yes.
Now, last column, row, my lord. This is past census 81, my lord. Buddhist 13, my lord.
Last column is column number 9.
9, my lord.
What is there in 9?
9, my lord, will be ratio of 51.60 is ratio of the believer of the indigenous faith, my lord.
51.60.
60, my lord. Earlier, down below is 71, my lord. In 71 census, they were 63.46, my lord. Now they have decreased, there is decreasing of, my lord, 10%, my lord.
Indigenous believers are decreasing in number.
Number, my lord.
Yes.
Now, ultimately, this 1971, my lord, law was to protect those people, my lord, from the conversion, my lord, to the other religion, my lord. Now, I'm indicating those all, my lord, due to non-implementation of this law, my lord, by the legislation, my lord, non-action of the executive, my lord. Day by day, my lord, we are this believer are decreasing, my lord. In 91 also, my lord, it become, my lord.
But religion is a matter of choice.
Yes, my lord, truly, my lord. What I'm that is true, my lord. What I'm saying, my lord, one, there is a law by the legislation, my lord. Now the executive, my lord, duty bound to implement that law, my lord. They cannot sit over the law, my lord.
What is this law?
This law, my lord, is that I have annexed, my lord.
Yes.
page number, starting from my lord, page number
21.
21, my lord.
You have to tell us about this law, what this law.
So, my lord, will 21, my lord, objective, my lord, will see, my lord, act, my lord, page number 21, my lord.
Ah.
To receive SN, my lord, of the President of India on 20 October 2019 and act, my lord. This is objective of this act, my lord, to provide prohibition of conversion from one religion paid to other religion paid by use of force or inducement by fraudulent means and for matter connected therein. This is the very objective, this is, my lord. According, my lord, law is there, my lord. Now I am saying, my lord, once this is, there is law, my lord, then in this law, my lord, need to be enforced, my lord. Now, in absence of framing of rule by the executive, my lord, this law is still only in book, my lord.
The rule will come next. How does it seek to prevent
To my lord, to
conversion from one religious faith to another religious faith by use of force and inducement?
it is it will, my lord, relevant section will be from page number 22, section 3, my lord. Section page number 22, my lord.
Can you tell us?
No, the section 3 say, my lord, no person shall convert or attempt to convert either directly or otherwise any person from one religion paid to any other religion paid by the use of force or by inducement or by any cruel means to, nor shall any person abet any such conversion.
Who is converting whom?
My lord, that religion from outside, my lord, if I,
What is the proof?
now that's why, my lord, I was indicating the census, my lord.
Census.
My lord.
Okay.
Ultimately, my lord, it is decreasing by in 1971, my lord, it was 60, my lord. Now in 91, it become 51, my lord.
But
Now-
see, that is all right. The indigenous faith believers are decreasing as per the census.
Yes, ma'am.
Data you have shown to us. But that does not indicate that that is because of the force, what is called? Conversion. Yeah, conversion from one religious faith to another by use of force or inducement.
Different.
People may have changed their belief by the choice.
That's why I am before this, not before, my lord.
Ah.
If suppose is this equal, my lord, given effect, my lord, by the executive, my lord, surely, my lord, today I could have indicate, my lord, who, my lord, who are those person, my lord. In absence of those rule, my lord, the rule framing of rule, my lord, I am unable, my lord, today, my lord, to indicate that those, my lord, who are person who are converting, my lord. That's why, my lord, I am before this, not before, my lord. Ultimately, there is some law, my lord, to
Use of force to convert a person's religion is not an offense under the IPC.
I surely, my lord, that I think, my lord, that offense, my lord.
If it is offense under IPC, you may file an FIR.
Yes,
We
my
don't know whether it is an offense or not.
lord, my humble submission would be, my lord,
Okay, what have they said in the affidavit?
they, my lord, they are also saying, my lord, yes, my lord, they are also worried, my lord, but they are saying, my lord, yes, this is a violation of 1978, my lord. Now they need to look into it, my lord. How, my lord, they can say that, my lord? They are not the legislation, my lord. The executive is saying, my lord, they need to look into this, my lord. Now that itself showing, my lord, they are somewhere else intended to, my lord, sit over the, my lord, command of the law, my lord. In para, my lord,
What is the punishment prescribed here?
Punishment is
2 years and 5 years.
2 years, my lord.
An offense under this section will be cognizant no prosecution for an offense under this section. See, Mr. Perme, you are not remediless. Even without the rule also, you can initiate an action.
Yeah.
See, offense is section 3. Punishment is section 4. offense is cognizable. Offense under section 3 is cognizable under section 4. But to launch a prosecution, you may have to seek the sanction of the deputy commissioner.
Yeah.
So you initiate that process.
My lord, I do consider, my,
Why do you need the rule?
what I'm indicating, my lord, this, suppose I initiate I have a remedy of initiating complaint, my lord. That is a particular remedy, my lord. What I'm told this PI, my lord, trying to seek, frame my, before this honorable court is, my lord, is there is a legislation, my lord, for the benefit of the masses, my lord, public, my lord, there is a believer indigenous, my lord. Now that need to be, my lord, give effect, my lord. Individually, yes, my lord, I can, my lord, file complaint under this act or the other IPC or any other law, my lord. But that is, my lord, my humble submission, that is the not issue before this honorable court, my lord. What I am trying to impress upon my lord, there is a law of legislation, my lord. Now, whether that
They may frame rule, may not.
my lord, what I am praying,
Is it mandatory to frame rule?
my lord, my humble understanding, my lord, once there is a command of law, my lord, legislation, my lord, executive is
See-
duty bound, my lord, under the
see-
constitution, my lord, to
See,
implement
see,
that, my lord,
If this legislation can be given effect to
my lord.
without framing of a rules, then this legislation will work for the benefit for those whom it is meant. Is not it?
My lord.
Now the rule making power is discretionary.
Truly, my lord.
If it's not working, in order to implement it, the act says that the government may make rules.
My lord.
Even without, see, even without the rule also, you have a remedy provided here. You are relying on section 8.
8, my lord, 8, my lord, truly.
It is not a mandatory provision. This is for the purpose that if the such provisions are all there in all the acts. If the act is not working for the purpose it is meant, then to fill up those gaps so that the act becomes workable, then the government may make rules. This is mandatory. How many complaints we have lost against the forceful conversion by fraudulent inducement? And the deputy commissioner has not given sanction to you. We can close this PIR. We think over it.
My lord, in that sense, my lord, I think, I believe, my lord, I need to read this May SSL, my lord. For that, my lord, I need, my lord, I think some preparation, my lord. Ultimately, this is mandate of law, my lord. What maybe can be read as a sale, my lord.
Who are you?
I am, my lord, I have indicated para, my lord.
And then the court is asking you, who are you?
5, my lord. I have
Correct,
indicated para 5, my lord.
Yes.
My lord.
Who are you?
Para 5, my lord. I have indicated, my lord.
Who are you?
Yes, my lord. My lord, presently, my lord, he is Secretary General, my lord, Indigenous Faith and Cultural Society of Arunachal Pradesh, my lord, petitioner, my lord.
And how many such instances you have come across? Where the believers of the indigenous faith has been forcefully converted to other faith by using force or inducement. And how many complaints you have lodged before the authority prescribed under the act to prevent that?
That I have, my lord.
You are after the rule.
Yes, my rule, my lord. That way, my lord. If my lord see kindly see, my lord, the in this, my lord, this, my lord. Ultimately, some, my lord, rule will be my lord.
If you can't answer that, you may find lack of bona fide in the petition also. And also on merit also, you have remedy. Today also, if you have any instances of such forceful conversion by use of fraudulent means and inducement, you can lose it. See, it's a cognizable offense. You can file an FIR. If it is a cognizable offense.
Truly, my
We
lord.
should investigate. For prosecution, you may have to take the sanction of the deputy commissioner. Remedy is there. You are not taking recourse to that, and you want the government to frame a rule. What, for what purpose?
My humble understanding, I believe, my lord has seen the definition, my lord, this rule inducement, my lord. Now, for that, my lord, I do believe how my lord that work, my lord, in the understanding executive, my lord. Ultimately, this believe my sensitive, my lord, religion, my lord, is sensitive issue, my lord. Now,
Nothing sensitive in religion. What is sensitive about religion? It's a freedom of choice. You want, you want to follow a particular faith.
yes, my lord,
People,
sensitive in the sense, my lord. Now, if suppose some conversion, my lord, the policy making within the religion, my lord. Now that suppose affecting particularly the innocent people, indigenous of these people, my lord. That, my lord, not be, my lord, tangible, my lord, in terms of this act, my lord. Now, my lord, for that I humbly believe, my lord, some rule, my lord, how, my lord, that can be identified, my lord, that needs to be framed, my lord, in this case, my lord. My humble, anyway, my lord, my humble submission, I need, so I believe, my lord, I need some preparation, my lord, in terms of May, my lord.
Filed the affidavit on 13/7/2023, my lord. We have already filed.
when did you file?
13/7/2023, my lord. As per my record, my lord, we have filed that.
Mr. L. Pervez, talking for the petition. And Mr. R. S. now, who submits that the counter affidavit by the state was, has been filed on 13/7.
2023.
2022, which however is not on record. Registry directly from this matter by placing on record the counter affidavit filed by the state. If your argument remains the same, we will close it.
My lord, only I can suggest my friends, my lord, they should have more faith in their own faith, my lord.
If you don't raise the bar of your legal submissions, we'll close it on the next day.
Okay, I will try, my lord, my endeavor to make it bigger.
My lord, the government is yet to file affidavit on this matter, my lord.
What is this matter about? What is the matter about?
My lord, this is a shifting of district headquarters from Pangin to Boleng.
Would you like to still pursue the PIL?
Yes, my lord.
Shifting must have been completed.
Yes, my lord. But this is
From which place to which place?
from Pangin to Boleng, my lord.
Boleh.
Yes,
Shifting of the.
yes, my lord. Earlier, my lord.
Headquarter must have been established in Boleh now, by now.
Yes, my lord. But there is a, my lord, government order whereby, my lord, it was clarified that both the places will be developed in terms of twin capital, Itanagar and Naharlagan, my lord. But the grievance of the people out here at Pangin is that, my lord, although they have donated sufficient land.
Ordered by whom? By the government
Yes,
to develop Boleh and Pangin like Itanagar and Nalaga.
yes, my lord.
Then let the government develop it.
But my lord, infrastructures, my lord, are being proposed in non-feasible area, my lord, against the will of the even public, my lord. Whereas, my lord, on Pangin side, huge area, my lord,
How much time?
Your Lordship, at least 4 week time may be given. From respondent number 2, Secretary Admin we have received.
Mr. And further on the petition. petitioners and this, and the chief honor on a government worker who prays for them and granted for the 6 weeks time to file counter listed after 6 weeks. Complaint. Account number 4.
May I please, Your Lordship? Your Lordship, in this case, the respondent are yet to file their affidavit in opposition.
Yes,
My lord, some more time maybe.
how much time?
My lord, 4 weeks time.
Mr. Aiva. And counsel for the petition and Mr. N also. Then additional book agreement for the step. Who prays for and granted 4 weeks time. For the 4 weeks time for filing of a counter agreement. Also have Mr. N argue for,
Respondent number 3,
who is respondent to?
Secretary.
Respondent number 2. Secretary. Yeah, administrative reforms.
No.
Secretary administrative reforms.
Definitely yes.
No, Secretary APS.
Respondent number 3 here.
Public Service Commission.
Or respondent number 3.
Three,
Yes. See, Mr. Bam,
Yes, sir.
on what basis you are seeking a criteria for selection to be framed by the government?
Okay, Your Lordship, I'm extremely sorry. My leading counsel will be in better position to reply to the answer, Your Lordship.
Leading counsel, who, Mr.
Answer.
Sekia.
Yes, Your Lordship.
What is pleaded there?
Your Lordship, as per my limited knowledge, we have only sought a relief to frame or formulate procedure or parameters.
No, that I have understood. What is the basis for? What is the basis of your prayer? That the government should frame a criteria or parameters for selection.
Your Lordship, as per clause 4 of Your Lordship, they have no, there is no, Your Lordship, procedure, mentioning of procedure for the appointment of chairman and their members, Your Lordship.
Yes, Rata. What is their pleaded?
In fact, they have, on the basis of the judgment passed by the Honorable
Yes,
Supreme
Your
Court
Which one?
and 2015-3 SCC, 13-5 SCC, page 1, State of Punjab versus Sahib
Khalil, Tablok and others.
Sahib Sablo.
BALLB case.
Yes, madam. Sahib Sablo.
Okay. The police.
Robert.
Khalil.
My lord, this item number 6-7, Mr. Jamu, my lord, I think letter of absence is there. He will be available from tomorrow. So
Your
basically, education department,
What is the matter?
Matters regarding your not.
well, it's an imposition of some charges for the private university, my lord, for enrollment or something like that.
You are also party, yeah?
I'm also party there, but basically education department, they have to answer to that.
Have you filed affidavit?
Affidavit, my lord, we have not yet filed, my lord. So can it be listed after 4 weeks, my lord?
Miss
C.
C.
Eating.
Hearing on the council for the petition. Mr. R.S. Navu, Governor Register of Good General,
Respond number 2, my lord.
correspondent number 2. Notice appear for the remaining respondent. Expected to Mr. Navu, you sit after 4 weeks for filing of a counter evidence by the respondent.
My lord. Both 6 and 7, my lord. 6 and 7 are analogous.
Okay, 6 and 7.
Yes.
Same number.
Obliged.
Any objection?
Regarding the
Condemnation of delay, no, since this is a jail appeal.
Okay, so we condone it. Or Mr. J. Tarak for the applicant, Mr. Ms. T. Jini, ABB for R1 and N. Langan for R2. This is an application. Under section 5 of the limitation act 1963, seeking condemnation of delay of 1063 days in filing the criminal appeal jail number 4 AP of 2023. Learned counsel for the learned APP as a learned counsel for the respondent has no objection if the delay of 1063 days in preferring the connected criminal appeal is condoned. So, upon learned counsel for the parties on non-perusal of the explanation provided in the accompanying application, explaining the delay of 1063 days in filing the criminal appeal number so and so, this application is allowed. And this application is allowed. Also, accordingly, the delay of 1063 days in filing the criminal appeal number so and so is your condom. I still allow them disposal. In view of the order passed today in I number so and so, this criminal appeal is taken up for admission hearing. G Tarak, the counsel for the appeal. EGD, APP for 1 and Nangan for 2. Admit call for the issue notice to the respondent, as the respondents are represented by the council, no further notes in the center. Extra copy of the appeal will be furnished to them. Call for the LCR. Notice is made returnable of 4 weeks, 6 after 4 weeks.
Always.
May I please, boss?
Yes.
My lord, this is also a jail appeal, my lord. My lord, I have one small period in this case, my lord. My lord, I have some reservation in this case, my lord. Therefore, I have some reservation in this case. My lord. Therefore, my lord, I may be allowed to recuse as an amicus curiae in this case, my lord.
Okay. This is come up for what? It has been already admitted, isn't it?
IA is there. One IA is there.
What is IFO?
Condemnation.
Condemnation delay.
You were appointed as amicus.
Amicus curiae, my lord, by this registry, you know. I have also made one application to the registry, my lord, to recuse me as an amicus curiae. Yes,
Okay.
really.
Then who will be here? Who is the-
Your Lordship, in
This
that,
this is what is the sentence?
Sentence is
it is
20 years.
20 years, Your Lordship.
20.
Under 376G, it was convicted.
The same case, earlier case.
Yes, Your
Yes,
Lordship,
ma'am.
it's
It's connected.
started in 2 heads, Your Lordship, therefore separate cases with it.
Which sentence?
Same to the earlier case, you just passed the order just now.
Item number 9.
Two accused being.
Yes.
Yes, yes, Your
Judges.
This is a condemnation application, isn't it?
Yes, Your Lordship.
Yes.
Okay.
Highest condemnation.
Where is the list? List of amicus? Here the respondent two has appeared.
No, not in this.
Notice was issued.
Notice was issued on the first stencil.
It. I received copy of the petition,
Yeah, mine
but. Okay.
But not.
Thank you. Minky was here, no? If
Not-
Tarak
not.
is there. Tagum can represent. T Tagum, Tava Tagum. Yes. What is this? Poxo.
No, your lordship, not
Three
POXO.
seven six.
376D, your lordship, gain rate
376.
D, your lordship,
D,
Huh?
D.
D.
capital D.
Lordship, even in this case, your lordship, as per the guidelines of the Honorable Apex Court, your lordship, the name of the victim may be not shown in the petition, your lordship.
Not shown in the.
Petition, your lordship,
Uh,
not reflected in the petition, your lordship.
My lord, it should not be reflected in the petition, ma'am. The name of the victim.
Respondent two is the victim.
Yes, your lordship.
Victim. Yes, Tagum, any issue?
Regarding this matter,
Will be comfortable, no?
issue.
Uh,
Lama.
the appointed amicus.
I'm sorry, my lord. This case, lordship, the previous one, and this case, they're arising out of the same judgment. So therefore, it may be
is
taken up
the-
together, yes.
Uh, on a reservation expressed by the earlier appointed amicus curiae, Mr. H. Lampu. Learned counsel, Mr. T. Tagum. Learned counsel is hereby appointed as amicus to represent the appellant, is not it?
Yes, your lordship.
Appeal of the appellant and the instant application as well as in the appeal.
Name.
Good, good. Then you write in the IA, heard Mr. T. Tagum, learned counsel for learned amicus for the applicant. Miss T. Jini, learned APP for one. None has appeared for the respondent number two, despite service of notice as indicated in in the office note dated 23/5/2023. Thereafter, same order in the interlocutory application where we have gone down 1063 days of delay. Then again in the appeal, you write the same order, only the council will change. And also say in the last list along with criminal appeal number so and so, earlier case, all right. Item number 9. All right. I hear this was.
And my
Your lordship, the,
my name may be my lord, directed to my lord, delete from the.
List it along with so and so by showing the name of Mr. T. Tago as an amicus curiae representing the appellant in the record as well as in the cause list post. Henceforth, Mr. H. Lampus name may not be shown as amicus representing the appellant either in the cause list, either in record or in the cause list. How much?
My lord, I may be, registry may be directed to apply required document.
Okay, okay.
victim.
Your Honor, I am the amicus curiae in this case. This is a IA number 26, filed in the criminal jail appeal. IA is filed for condonation of delay of 808 days.
Okay. Jail appeal,
Yes,
you are an amicus.
yes, Your Honor.
Okay. Any respondent number 2 has been served.
Nobody is appearing on her behalf. I believe it's not yet been served.
Service reporting. Yes, any objection? No objection.
No, your lordship.
Miss
SB Dara.
S.B. Darangana counsel for the applicant and Miss T. Vinny. APP for the state. None is appeared for the respondent number 2, respect service of notice. As indicated in the office note dated 23/5/2023. This is an application, etc. for condemnation of 808 days.
Yes.
Same order.
LCR may be.
In the appeal. SB Dara, the same order. In view of the order passed to this answer, this appeal is taken up for admission hearing. The SB Dara counsel for the appellant, along with the amicus.
Yes.
Amicus for the appellant and Ms. T. Zini, counsel for the APP. Here also we are required to take fresh steps to the in the appeal.
Your lordship, this was the reason, your lordship, as per the guideline of the apex court, your lordship. The name of the victim should not be reflected in the petition, your lordship. Even in this case, it's a case of 376D, your lordship. Now, if the names are not being reflected, your lordship, normally counsels are appointed from legal aid. Counsels are being appointed to represent on behalf of the victim, your lordship.
Okay. On the next date,
Yes,
we'll appoint. Admit call for the. No, what I'm asking is. After after this appeal is admitted,
Yes, your lordship.
are we again required to serve notice to the respondent?
No. As per the recent, your lordship, there is not necessary for service of notice upon the informant or the victim, your lordship.
informant of the
or the victim, your lordship,
or the
victim,
notice is not necessary.
not necessary, your lordship.
Has
As
it
per
been changed?
Jagjeet, yes, your lordship, of our own bench, your lordship, of bench of Honorable Guwahati High Court Principal Bench, your lordship, on a recent decision, your lordship.
But
Jagjeet,
see, if it is not, if the notice is not required,
yes, your
then why they have been made a party?
Yes, your lordship, therefore, your lordship, if a party has been made in the petition, your lordship, notice may be issued accordingly, your lordship. However, it's not mandatory to make them a party or issue notice in that regard.
Why did we started making victim or the informant a party?
As per the judgment of Jagjeet Singh, your
Jagjeet
lordship.
Singh.
Yes, your lordship. Subsequent,
Now,
no, after Boromati Pangin, Jagjeet Singh came in.
so has that law been changed?
Your lordship, as per the division on previous occasion, the same division bench, your lordship, of our High Court, your lordship, has made us aware that there is a recent judgment, your lordship. I'm not able to get the judgment, your lordship, that detailed discussion was made with regard to even Jagjeet, the interpretation of the Jagjeet Singh with regard to the notice being issued to the victim or informant, your lordship, mandatory notice, your lordship. Subsequently, this there is an order from this honorable court that it's not mandatory, your lordship.
I'm not aware of that. I'm of the opinion that it's mandatory for the victim.
No, it is something like this. Earlier, because of our decisions,
Yes.
decisions of our court,
Yes,
we are making parties.
yes,
That was changed
yes,
by a subsequent decision. Then we stopped making parties,
yes,
correct?
yes,
The victim or the
yes,
informant.
yes.
Then this Jagjeet Singh came. Now, somebody from the bar pointed out that the Jagjeet Singh, yeah, as per the decision in the Jagjeet Singh, we have to make a party. Then we started making the informant a party.
Yes,
Later on, somebody again told that no, Jagjeet Singh does not mandatorily say so.
yes, your lordship. It was learned counsel D. Pangin, your lordship. That was an argument placed before this.
That must we are aware of it.
Yes, your lordship. On the
I
last,
have not read Jagjeet Singh.
on the last occasion, the same division bench of this same court has apprised us that there is a recent order of the division bench of principal bench, your lordship. While interpreting the entire,
All right, in view of the so huh? This is taken to the SB double person, so admit,
For also in rape cases, rape cases, I think it's mandatory.
admit, call for the LCR, issue notice to the respondent. As Ms. Lin runs also, land APP has accepted. Has entered appearance and accepted notice on behalf of the state. No formal notice is required to be sent. This is jail appeal, no?
yes,
Registry shall. Registry shall serve notice upon the respondent number 2. List it after 4 weeks.
deeply.
Also obliged.
Non-abuse. For the appellate. How with the Office note dated 15/7/23 indicates that AD card of respondent number 2 is yet to be received. In view of the above listed again after 3 weeks.
My lord, I have taken the service, my lord. Oh, I have served the service. My lord. My lord, this is a condemnation of delay.
Condolence application.
Yes, my lord. Praying for
In preparing the writ appeal.
yes, your honor. Read appeal number 493, 2019.
Yes. First comes. Any objection?
My lord, here I am appearing on behalf of respondent number 1 to 6, my lord.
One,
In
two,
fact,
six.
yes, my lord.
Yes, what do you say?
Lord, order which is under appeal has been filed in presence of them, my lord, and the copy has been duly, my lord, parnished, and the proceeding was duly within the
That
knowledge.
is, object to.
However, my lord,
If you object to, you file objection.
there is a delay of 313 days. Otherwise also, my lord, the appeal may be heard, my lord. My lord, otherwise also, my lord, merit is to be done.
No
No
objection.
objection.
Both of you are appearing for? Okay. 18. Any objection?
No.
Oh, Mr.
Odugo.
Odugo, Learned Council for the application. Mr. M. Katul, Learned DSGY for
1 to 6. my lord.
copy number 1 to 6.
What's the
Yes.
for 7 and 10?
Yeah, Mr. G. An additional senior government worker for respondent.
Yes.
7 and 10.
Yes.
And Mr. D. Kamlu, standing counsel for the LM for R8 and 9. This is an application under section 5 of the Limitation Act 1963 for condemnation of delay of 313 days in filing the writ appeal number 18 AP of 2023, which appeal is directed against the judgment and order dated 14/6/2022 passed by the non-single judge in WPC number 493 AP of 2023. Council appearing for the respondents. Mr. Dave, no objection with the delay of 312 days in filing the writ appeal is standard. Upon having a counsel for the parties and on permission of the explanation provided in the accompanying application, explaining the reason for what is the reason?
My lord, region is my lord. They have passed the order directing
Delay of 313 days in filing the connected writ appeal. We are satisfied that the applicant was prevented by sufficient cause in not preferring the connected writ appeal within the stipulated time. In view of the this application for condemnation may be allowed, and the delay of 3 days in filing the connected writ appeal is hereby condemned. I extends allowed in this program. What do we do with the appeal?
Notice
Yes.
may be issued, my lord.
Huh?
Well,
Appeal
My lord, no,
dismiss.
my lord, notice may be issued, my lord. This is my lord. Next date may be given.
What,
I have not, my lord, notice may be issued, my lord,
what notice?
for service of
Notice-
the copy
Notice
of
will
writ
be
appeal.
issued if we admit it.
My lord, then my lord,
There's no merit in the appeal.
my lord,
No wrong with the order passed by last single day.
my lord, orders, my lord.
In view of the order passed to the interlocutor application so and so, and as prayed for by Mr. O. Dugunlane Council for the petition, will list it after a week for admission hearing.
Oblast.
Okay.
Development.
Lordship, here we need time to file our affidavit.
What is this matter?
The promotion matter, your lordship.
Oh, validity of rule has been
Rules,
challenged.
yes, your lordship. Rules has also been challenged.
Not Mr. O. Dugunlane Council for the petitioner. And Ms. R. Vassal, government advocate who prays for and is granted 6 times to file counter evidence. Listed as 56.
Oblast.
Yes.
Your Lordship, I beg to mention item number 22.
Yes,
Item number 22, Lordship.
22.
Yes, Lordship.
Yes,
The leading counsel is out of his session.
what is this matter about?
It's supersession of seniority list
Okay. When do you want?
after 4 weeks.
Okay, on the prayer of Miss. Your good name?
Margam Basar.
Margam Basar.
Yes, sir.
Learned counsel for the petitioner. Petitioner.
Yes, yes, Lordship.
This is after 4 weeks.
Oh,
Your Lordship, I like to mention unlisted matter, listing for tomorrow. Yeah, it's a service matter. My bad.
Lordship, I would like to mention item number 19.
Yes.
I'm for the petitioner. Petitioner not interested to further proceed the matter. So I may allow to withdraw the matter.
Okay. Your name?
People.
Mr. T. Paul, learned counsel for the petition or instruction seeks to withdraw the petition. First, the petition is dismissed and withdraw. Interim order pass if any instance vacated.
Much longer.
May I please, Honor? May I please? The contempt petition has been filed by the petitioner against the contemner for willful disobedience of order dated 30/6/2023, which was passed by this honorable court in WPC number 310 of 2023. In this writ petition, the petitioner was claiming that the respondents, the medical department of Likhavali, had demolished and evicted the petitioner without giving a fair chance of hearing, and as against the provisions laid down under Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act. If I may invite your Honor's attention to page number 31, Your Honor. Oh. Page number 33, Your Honor. The order passed by this honorable court, annexure number 5. Particularly in page number 35, this honorable court had observed that meanwhile, as prayed for by the learned counsel appearing for the petitioner, impugned notice dated 17/4/2023, white so and so number, order dated 19/5/2023, and order dated 31/5/2023, white so and so, passed by the Deputy Commissioner, Lower Siang District, Likhavali, Arunachal Pradesh, shall remain state till the next returnable date. So interim prayer was granted. And accordingly, the order was placed before the Deputy Commissioner as well as the District Medical Department in Likhavali, which is the forwarding letter is at page number 36 and 38, annexure 6 and 7. Even after the forwarding letter was submitted to the authorities and the honorable court's order was placed before the authorities, the district medical officer, that is the respondent here in Yagege, he continued to construct continued with the construction process in the land of the petitioner. And accordingly, because the respondent was not stopping the construction, the petitioner had submitted a representation to the Deputy Commissioner of Likhavali as well, which is at annexure number 8. And thereafter, the Deputy Commissioner has passed an order, which is at annexure number 9, page 41, if I may read on. It is written that whereas a complaint has been received from Sri Tagamaruti of Liru village, intimated that the Honorable High Court issued order on 30/6/2023 by staying the notices of dated 17/4/2023, 19/5/2023, and 31/5/2023 of this office till next returnable date. But construction work is going on by the executive agency contracted at evicted plot of land. Hence, both the parties are hereby directed to maintain status quo over the disputed land and refrain from any kind of construction work till the settlement of the case. However, the contender herein has not stopped the construction and is still continuing with the construction, and the pictures with regard to which are annexed in annexure number 11. The last date of construction, the update that we have so far is of 12th of July 2023. The construction was still going on.
What are these orders? 17/4/2023.
These orders were passed by the Deputy Commissioner for directing the petitioner to evict from the premises.
Okay.
Although it is the case of the petitioner that he has been residing in the land for more than 38 years.
19/5/2023, 31/5/2023. All passed by the Deputy Commissioner.
All passed by Deputy Commissioner Likhavali. All of these are impugned orders in WPC 310, in which the
Then-
interim prayer was granted.
Who has evicted you?
Eviction has taken place under the direction of the Deputy Commissioner by the Police Department.
By the Police Department.
Yes, Your Honor.
Then why have
The
you?
house was demolished. The house of the petitioner was demolished. But now what is happening is the district medical department is trying to construct a structure over the land and they are trying to claim it.
No. Who has violated this order? 36/2023.
The district medical officer, Mr. Nyage Gei, district medical officer of Likhavali. Representation is at,
No. Did he demolish your house?
he did not demolish the house, but he is constructing in the house, in the land of the petitioner. Because there's an interim stay on the orders. There,
See, just a moment. Interim order is at page 35.
page 35.
Whereby this 17/4/2023, 19/5/2023, 31/5/2023, orders passed by the deputy commissioner was stayed.
Yes, Your Honor.
Now, what are these orders?
These
The-
orders are annexed at page 16, annexure number 1,
16,
page 16, annexure number 1.
6. Yes,
Whereas a complaint against you,
as you are here were notice to vacate the department plot. Okay, then where is the next order?
thereafter, the contention.
19/5.
Yes, Your Honor. The contention is that the petitioner has filed a reply, which is at the next page, page
No,
17.
It's all right, it's all right. Then
And
where
then-
is the next order?
Next order is at page 19. Oh,
Where is 19?
apologies, Your Honor, no. Next order is at
Page 19.
next
Well,
order is at page 31,
17 April, same order. And then page
page
31.
31.
31 is the okay, last order, 31st May.
And 31st May is at page 32.
So when, on which date you were evicted?
21st. 21st
21st,
of June.
21st of June.
Yes, Your Honor.
21st of June.
Um, 21st of June.
21st of June.
Yes, Your Honor. At around 1 PM. Mentioned at para 7 of my petition
There are 7. By whom?
by the police department.
By the police department. So nobody has committed any contempt because these letters were stayed by this court on
Yes.
30 June. Is not it? 30
Yes.
June 2023. By the time you were already evicted.
Yes, Your Honor. The
What-
house was demolished.
The house was demolished.
Yes. You know, although my challenge before this honorable court in WPC was that the eviction itself is illegal. They have illegally evicted me from my plot of land.
We will then list this matter along with WPC.
Yes, Your Honor. Notice may be
See,
issued.
No contempt appears to have been committed by this district medical officer.
No, because there are representations that we have filed and there's an order passed by the deputy commissioner himself that no construction should take place in the plot of land, but they are still constructing. So by the time this matter is disposed of, they'll already have a structure standing there. And the petitioner is claiming it to be his land and he's been residing there for more than 38 years.
Administrative and counsel for the petition. List this contempt petition along with WPC 310/2023. The contempt petition perhaps is misconceived. Contempt is for violation of the order of this court. You know that. Your eviction order was stayed by this court. But you were evicted prior to that. So nobody appears to have violated.
Your Honor, the petitioner was evicted.
Now it appears on that vacant land, the district medical officer is constructing a house for the health department. And the dispute, and it is a land dispute between you and the medical department. Medical department says you have encroached upon the public premises. The land which were under your occupation is a public premises belonging to the health department. So that is why the Deputy Commissioner has initiated action against you under the Public Premises Act.
That has not been proved by them. They do not have the map also. That itself is
So
challenged in
that appears to
WPC.
be the case. But this DMO has not committed, appears to have not committed any offense. Sorry, any contempt. We look at it, we'll take it up along with WPC.
My lord. Eviction notice has been issued, my lord, which has been challenged in the instance petition. My lord, this petition is under the position of under my position since 1998, when I'm constructing a small house. All of the sudden, eviction order has been issued without hearing him,
Where?
without so cause notice.
What is the improvement order?
My lord, it is in page 10. 10 and 10 is 11 is the type of my lord. Page 11. My lord, it's 40%, my lord. Whereas, despite the verbal informing you about the dismantling your unauthorized structure nearby FCI godown, cooperative line toothing, it has not been yet dismantled. Now you are hereby directed to remove the unauthorized structure and fill the hole with stone and sand drilled by you within 7 days, following to which eviction drive shall be initiated and cost of expenditure shall be borne by you. It is issued on 14 July 2013.
Yes.
Without
Yes, my lord. Here, my lord, page number 11, my lord, this impugned order, my lord, this should have been issued under section 4, my lord. For Remissions Act, my lord, unauthorized Remissions Act, my lord. But this is, according to me, my lord, I'm sorry, but it's wrong, my lord. This
All
one.
right. Mr. Odugo. Along with counsel for the petitioner. Right. Miss T. Wang, along with government advocate. Representing respondent 1,
1, 3, and 4.
3,
my lord.
and 4. As well as Mr. D. Kamlu, along with standing counsel for the earlier, representing respondent number 2. This petition is directed against the letter dated 14 July 2023, issued by the in-charge circle officer, Circle officer,
yes,
circle officer,
In charge, my lord,
in
86.
charge, additional deputy commissioner, Upper Siang District Duty, by number so and so at page 10 and 11. Directed to the petitioners. Issued to the petitioner by number so and so, whereby petitioner has been directed to remove the unauthorized structure. Just whereby it has been stated that despite verbally informing the petitioner about dismantling about the unauthorized structure of the petitioner nearby FCI godown, cooperative line, tooting, it has not yet been dismantled. And therefore, the petitioner has been directed to remove the unauthorized structure and fill the unauthorized structure within 7 days. Full stop. The condition of the petitioner is that the impugn letter dated 14 July 2023 has not been issued in consonance with the Arunachal Pradesh Public Promises Eviction of Unauthorized Act 2003.
Three.
Full stop. The London State Councils have also not disputed that the impugn letter have also not disputed that the proceeding is initiated by the circle officer stroke in charge additional deputy commissioner Upper Siang District Tuting by the impugn letter dated 14 July 2023 appears to be not in accordance with the Arunachal Pradesh Public Promise Eviction Unauthorized Act 2003. In view of that, we've had a running council for the parties and on and also having perused the impugn letter dated 14 July 2023. This writ petition is disposed of at the stage of motion hearing itself by setting aside the impugn letter dated 14 July 2023 written to the petitioner by the in charge deputy commissioner of file number so and so by providing liberty to the respondent authorities to proceed against the petitioner in accordance with the provisions of Arunachal Pradesh Public Promises Eviction of Unauthorized Act 2003 if the petitioner is found to be in occupation of any public premises. The petition is disposed of in council.
May I please, my lord?
Yes.
My lord, item number 1 is contempt petition, my lord. My lord, this contempt petition has been filed against the alleged contender, my lord, for willful disobedience of violation and deliberate violation of the order dated 23/8/2021, my lord. In
Page number.
Page number. It starts from page number 11, annexure 1, my lord. Operative portion is in page number 14, my lord. Considering the, I read, my lord. Considering the contents raised by the petitioner, no compensation has been paid to the petitioner by the authorities till date, despite the compensation assessment have been finalized at rupees 18,69,000 only for the assets of the petitioner falling under the chainage number such and such in the compensation assessment report of NH 415 from Itanagar to Bandardeva for construction of 4-lane national highway in the interim it is provided that no construction shall be undertaken by the respondent authority in the chainage number such and such of the compensation assessment report of NH 415 from Itanagar to Bandardeva for construction of 4-lane highway till the returnable date. Despite this order, my lord, the construction has been taken place on 16, 17, 18, and 19th of December, my lord.
15, 16, and 19 of December.
Yes, my 16, 17, 18, and 19th of December.
Yes, and
Yes.
now
Now, my lord, the respondent number 3, DC has filed the affidavit, but the main contender, my lord, main alleged contender, respondent number 2, my lord, is not appearing despite the service of notice.
who is respondent number 2?
Sri Sunyak Sumian, Chief Engineer, Highway PWD, Itanagar, Arunachal Pradesh.
Who has constructed?
Under his assistant, his subordinate officers, madam, Assistant Engineer, PWD Highway Division. Sorry. Executive Engineer Sri Bini Pelen and Assistant Engineer Sri Devya Takam.
Who has violated the order?
My lord, the contempt, alleged contender number 2, my lord.
He is not before this court.
No, my lord, despite the service of notice, my lord.
What about respondent number 1?
Lordship, I am appearing for respondent number 1.
No. Has the respondent 1 violated the order?
No, my lord,
No,
No, my
I'm
lord.
saying,
What about respondent number 3?
DC, my lord. He has filed the affidavit in
No.
opposition.
Has DC violated the order?
The My lord, the certified copy of the order was given to the DC, my lord, but no steps has been taken to prevent that construction, my
You
lord.
have to establish who has violated the court's order. We will not find out who has violated the order. No, respondent 1 has not violated.
No, my lord, but my lord, he has also received the order, my lord, and he has.
See, Miss Karvak,
Yes, my lord.
you started your argument that it is the respondent number 2 who has violated.
So he's the main contender, my lord.
How many contenders are there?
3.
3.
Yes, my lord.
All of them have violated the order.
Sorry, my lord.
All of them have violated the order.
Yes, my lord, the contender number, the respondent number 1, my lord. As he is in receipt of the order, my lord, and he has the supervisory power, my lord. He could have prevented this, my lord.
Okay, yes, then what else?
And my lord, respondent number 2, my prayer is that stringent action may be taken against the respondent number 2, my lord. He's not appearing before this court despite the
Only
service.
2.
No, my lord, because he is not appearing, my lord.
What about 1 and 3?
1 and
Since they have appeared, we should not take any action.
No, my lord, action may be taken against them also, but my
You
lord,
prepare your case and come back. Today you appears to be not very clear. Writ petition is also pending.
sorry, my lord.
Writ petition is also pending.
Yes, my lord, pleadings are not completed
Pleadings are not completed.
in the petitions.
Yes. What is to be done? Who able to?
my lord, in writ petition, I am for.
I'm appearing only in contempt petition for responding. You have filed a affidavit
Respondent number
3
3.
in contempt petition.
Ah.
Not in petition.
Huh?
Not in this petition, but in contempt petition, I am appearing for respondent number 3, deputy
Ah.
commissioner. ICR.
Yes. What do you say? What do we have to say? She is alleging violation of the order of this court by you.
No, my lord, we have not violated any order of this sort of court.
There was no construction undertaken.
Construction was there, that is by the highway department, PW department.
Okay. You have filed affidavit.
We have filed affidavit.
So we dropped the proceeding against respondent number 3.
No, my lord.
He is saying he is not violated. So you have to show in what manner they have violated.
It is BS, my lord. He is not giving compensation. Now he is also defending that the alignment has been changed and everything. When it has not been changed, construction has taken place.
In that case, I think writ petition has to be decided whether alignment change or not.
So let us then take up the writ petition. Yes. Which writ petition you are arguing?
Sorry, my lord.
Am I not audible?
264,
264.
Devia Pola.
Yes.
Item number 3.
264.
Yes.
Yes.
The petitioner has a plot of land, my lord, by virtue of allotment order number LRB 0929794. My lord, page number, annexure number 1, ma'am. Page number 26.
Yes.
My lord. And page number 29 is the notification, my lord, issued by the Secretary Land Management. For construction of National Highway, Itanagar to Bandadeva, my lord. Thereafter, my lord, in 2nd May 2016, another public notice was issued by DC ICC Itanagar Capital Complex, my lord. My lord, whoever's land was affected by the construction of the highway had to file claims and objections by this order, my lord. Thereafter, my lord, a committee of 7, one committee was formed, headed by Ms. Tame Ajun EAC, my lord, for the disposal of the claims and objections. And thereafter, my lord, the name of the petitioner, the petitioner's land was also affected. He had filed his claims and objection, and his name was, his land was also assessed for compensation, my lord. My lord will find his chainage in page number 61, my lord. Chainage number 4th from below, my lord. Devia Pola, RCC building. 18,69,000 was arrived at his compensation, my lord. Thereafter, my lord, several notice, public notice was issued saying that all the beneficiaries bring their document, this compensation will be dispersed. But it was not done, my lord. My lord will see in page number 37. It was published on newspaper, my lord, 20th May 2021. My lord will find in 346, serial number 346, Devia Pola. May I read, my lord? The above persons, while following the SOP of COVID, should bring the following documents in support in the claim, without which no check will be issued. And my lord, he was expecting that compensation will be paid, but it was not paid, my lord. Thereafter, again a notice was issued saying that re-verification has to be carried out, and petitioner's name was also there. Thereafter, again, a public notice was issued saying that collect your compensation, but it was not paid. It has not been paid till date, my lord. The petitioner has even filed a representation, but it has not been attended to. My lord, the assessment has been carried out in 2016.
You are for the compensation here.
Yes, my lord.
What do they say in the affidavit?
In their affidavit, they are saying that a fake assessment.
Hmm?
Fake assessment.
Fake assessment.
And the assessment has been carried out by them only. It has not been carried out by me.
Which respondent says that it was a fake? It was a
Respondent
fake
number 3. DC.
assessment.
Illogical assessment report, they are saying.
Where?
In paragraph 12, my lord.
Respondent number 1 has filed affidavit.
No, my lord. Respondent number 1 and 2 has not filed their affidavit as yet.
Where is that fake assessment?
In para 12, my lord.
Para 12. Yes.
They are now saying that the petitioner has misled the district administration by showing illogical assessment report. In
Yes. Who appears for the respondent number 1?
Lordship, here in this case, Lordship, the assessment, everything, it was done by deputy commissioner, and therefore the affidavit of the deputy commissioner will suffice. Because the acquisition, in fact, they are saying that, Lordship, after the acquisition of the land, while the construction of the road was going on, the alignment was changed in between. So he land doesn't fall under the this road construction lane.
Where is that?
That Lordship, he'll be able to.
Lordship may come to my para 8, Lordship.
Yes.
Lordship, this petitioner, he have a land measuring 225 square meter only, Lordship. And this plot of land falls within right of way. And as part of notification, it has been already declared that right of way won't be given, Lordship, compensation. Unless it is PROW. Proposed. Proposed right of way, unless it is proposed right of way.
What is right of way?
Right of way is, Lordship, is from center line 20 meter from center line each. If it is if his land, anybody's land falls within right of way, center from the center line 20 meter, they won't get lots of compensation.
Who determines this right of way?
Lordship, notification, Lordship may kindly see the notification.
And is that notification issued under some statutory provision?
Lordship is issued by the secretary. Then Lordship, Annexure A, Lordship. Lordship, in pursuance of the cabinet decision dated 16 March 2016, under agenda item number 4, the governor of Arunachal Pradesh is pleased to notify the following specifications of right of way. That is widening of existing 2-lane to 4-lane dual carriage way of NH 52A, new NH 415 from Itanagar to Bandadua. Right of way of 30 meters in the built-up area for the proposed 4-lane highway from Itanagar to Bandadua is below. Itanagar Chandranagar Bridge to Hotel Todo, and 2 Naharlagan Him Petrol Pump to Kankarnala Bridge.
So this right of way has been decided by the cabinet.
Here it's been said that Lordship, the deputy commissioner is following the secretary notification only. Yeah,
This secretary notification,
this is notified by the secretary.
right of way means
Lordship will see here,
30
right of way, yeah, in built up
area,
area is 30 meter, and in right of way in serial number 2, Lordship is 40 meters in the green field open area. No compensation shall be paid for the land structure falling within the right of way of existing alignment NH 450. Lordship, let respondent number 1 file affidavit.
no, he's
regarding
saying
this.
he will not file. Deputy commissioner is competent. He will rely on.
Notification is issued by the secretary only, Lordship.
Yes, in that
And we
case,
are
Lordship,
following secretary's
let
order.
me file affidavit. In fact, here in this case, they are not challenging this notification indeed. But
No,
there,
What is the
the
legal?
petitioner, what he
No.
is seeking is, although there was an assessment, her land was also taken over by the district administration for the construction of the road.
No, just.
Even after the assessment,
we-
despite
no, We would like to know what is this right of row concept?
that, in that case, Lordship, although she
That-
has not
let-
challenged this notification,
that-
let me
that-
come up with a proper affidavit, Lordship. In that, particularly on the issue.
But you appears to have no intention to file affidavit.
In fact, that is why Lordship, because this notification is not under challenge. I was of the impression that Lordship, since he is claiming the compensation and the disbursement authority is the deputy commissioner. And the assessment, all these things. It has been done by the deputy commissioner and the highway authority. So I thought that Lordship, the affidavit filed by the deputy commissioner and the highway authority will suffice.
Lordship, we are not making payment saying that it was within the right of way.
You're not saying so.
No, we are saying that,
Ah,
Lordship, in our affidavit.
okay, but what about this document shown by the petitioner that you had prepared a chart, compensation chart
Yes, Lordship.
at page 61, his name is there, 18 lakhs. And then you have also invited him by newspaper publication to come and collect the compensation at page
Lordship.
37.
Lordship,
What
That's
about, what
Yes,
about
Lordship.
those actions?
I agree that Lordship, but then in para 8, I have already Lordship,
18,
in para 8,
para 8,
yes, we have said that. Lordship, para 8, Lordship.
Ah.
Here, Lordship, your humble deponent submits that the public notice were issued from the office of the deputy commissioner by so and so, dated 2nd July 2021, and directed the genuine land affected beneficiaries of 4 land NH 415 to be present at their respective plot of the for the disbursement of the compensation on 5/7/2021. But the case in hand, although the name of petitioner enlisted under serial number 346, but then he is not eligible for the compensation as none of petitioner's structures as claimed by the petitioner falls within the proposed right of way. So the petitioner's representative could not be considered.
Then who had prepared this document, 18 lakhs?
For that, Lordship, they have said that in paragraph, Lordship, which the learned petitioner was reading it out, Lordship, just a second. That they have showed, Lordship, in para 12, they have said that the petitioner misled the district administration by showing fake claims, Lordship. That is what they are countering, Lordship.
Paratrial of whose? Yours or theirs?
Showing fake claims, Lordship, to the district administration, they are.
Fake claims. You are saying it is a fake claim,
Yes, Lordship.
but this appears to be your document.
Yes, my lord, this document has been obtained through RTI by the petitioner number 2. By the petitioner in item number 2.
And if you say that it is a fake, then what about this newspaper publication? Who had published this? At page 37? You have enclosed incomplete documents, annexes. Author of the document is not there.
My lord, in page 39, there is another public notice published by Talakotam, the Deputy Commissioner, Itanagar Capital Complex.
What about 37?
This was also published by.
Without solving 37, we would not like to jump to 39. So Karvak, that way, your case will linger on like this. Huh?
These are prepared by Deputy Commissioner, my lord.
But where is the author of the document?
Oh, my lord, will see in the heading, my lord. Government of Arunachal Pradesh, Office of Extra Commissioner, Itanagar Capital Region. My lord, page number 38 is also public notice issued by the DC listing the name of the beneficiaries to come and get their compensation, man.
Mr. Kamduk, you would like to file affidavit?
Lordship, this honorable.
No, we can't
My
say.
affidavit is dated, Lordship. Otherwise, Lordship has same Lordship.
We can't say. If you wish to file, you file. Otherwise, we will proceed.
I'll file Lordship. I'll file affidavit Lordship. Otherwise, Lordship, what I can gather from the writ petition and the affidavit filed by the other respondent Lordship. It is only the tussle. The problem is with the district administration. Although we have acquired the land, and now since it has been handed over to the executing agency, we do not have any.
Though Mr. D. Kamduk Kulandet, Standing Counsel for the Land Management Department, had initially submitted that the Department of Land Management would not file counter affidavit in this two writ petition and would rely on the stand taken by the Deputy Commissioner, the respondent number 3 in the counter affidavit file. But during the course of the hearing, he has submitted that the Department of Land Management he has submitted that it would be necessary for the Department of Land Management to file counter affidavit in these two writ petitions, for which he pressed for and is granted 6 weeks time. We still okay, 6 weeks.
Much obliged.
If you want to get the matter disposed of, you have to come prepared,
Yes, my lord.
not here and there, beating around the bush. And you know that document, you have a relook at the documents annex also. Yes, next.
My lord,
Otherwise, case will linger on like this. Yes.
my lord, only the issue. What need to be clarified that Department of Land Management is the provision for this ROW. Can it be brought by way of this instruction also?
We are not saying anything. We will take a call. Only thing is that we are not receiving proper assistance from either side.
Lordship.
Moment we get the facts correct, we'll take a call. But at the moment, we are not getting assistance, proper assistance from either side to do justice to the petitioners or petitioner as well as the respondents. We'll take a call. All right.
Much obliged.
This matter, my lord, the pleadings are complete.
Hmm?
Pleadings are otherwise complete.
My lord, in fact, matter was heard by your lordship, my lord. I will pray that this matter may be disposed of today. So I will submit the facts. Well, this matter regards to appointment of Arunachal Pradesh State Electricity Regulatory Commission member law. There is two members been proposed by the state government. One is for the chairperson and another is for the member law. Under the act that is called the Electricity Act 2003. So there was an advertisement because there was a beacon in the state. There was an advertisement alert. I will just take to the advertisement. Page 20 and 20A. Because advertisement is important because there it is mentioned experience. So I will just take to the page 20A. And type copies in 20A. May I read the first line? The government of Arunachal Pradesh invites application for the post of member law of Arunachal Pradesh State Electricity Regulatory Commission to be submitted in prescribed format letters by such and such date 29 July 2022 to the Under Secretary Power, Civil Secretary Tanagar. Interested candidate may visit the following website for details. So this is the format. And then your lordship, serial number 9 is important. Detail of experiences. Detail of experiences. 10. Any other relevant facts relevance may like to share. So now the applicant has filed application as per the format. My lord, I may take to page 23 to 24. This is the application was submitted on 22/7/2022. Page 23, my lord. Page 23, my lord.
Yes.
23 is annexure 3. So now here, application is the format, and as per the advertisement, it is mentioned experience. So he has submitted what is his experience. In serial number 9, details of experience. 1. Practicing law for 20 years in the Guwahati High Court. And then also mention principal seat Guwahati High Court, Assam since 2002 in the civil and criminal side. 2. Appointed as a public prosecutor from time to time, or also a defense lawyer, and had the experience of conducting both criminal and civil cases before the district and session court, additional district court, and then first track court. 3. Have experience of conducting cases before the Motor Vehicle Accident Tribunal, Juvenile Justice Board, Consumer Dispute Redressal Forum, and Central Administrative Tribunal. 4. Having also experience of conducting criminal and civil cases before the Court of Chief Judicial Magistrate, Judge of Senior Judge, the Judicial Magistrate First Class, come Civil Judge Junior.
All right, you have
Yes.
vast experience.
Yes.
What happens?
So now I have this experience. Now this the application was submitted, and then government has issued a notification for a selection of committee. I'll just take to page 35 and 36. The government has constituted the committee 35 and 36. May I take to annexure C 35, dated 3rd October 2023. The committee is constituted of retired Honorable Mr. Justice C.R. Sharma, the chairperson, and then second is the Gan Sayam Prasad, chairperson, ex officio secretary. Third is the Dharmendra IS, chief secretary, government of Arunachal Pradesh. Now, this 3 expert committee has gone through all the applications submitted by the applicants. Total, there is a 14 applicant. And then 14 applicants, they have prepared the comparative list, my lord. So I'll just take to the comparative list submitted by them. It's on page 66 and 68. There we will see how much experience the petitioner has and how much the respondent has got the experience. Because this act requires the person should have a substantial experience in the practice in the law. That is required by this advertisement, and it is also required by this act. So now this committee, I will just take to the comparative, and I will show there also it shows the experience of the respondent number 4. I'll just take to the page 66 and 68. And 68. It starts from 67. And 68. So now the petitioner is in the serial number 10. Serial number 10. His experience is clearly mentioned in this comparative statement. And your lordship may see the experience of the respondent number 4 is in serial number 11. Page 68.
Yes.
Serial number 10 is a petitioner and serial number 11 is a respondent. Now I'll just take to the serial number this petitioner, which I have already read the experience, which is also reflected in this comparative statement. And now serial number 11, lordship may place to see at serial number 11.
Yes.
See the experience site. Advocate with effect from 25/6 to 2012 till date. That is one. Another experience is that in social activities. So this much experience he has, he said, and there is no any experience he has submitted. He said that he is only a lawyer since 25/6/2012 to till that much. Now after that, what happened? The minutes of meeting was prepared by the selecting committee. I'll just take to the page 37 and 39. The expert committee had a minutes of meeting, and then they prepared the list of the applicants. So I'll just take to the page 37 and 39. 37 and 39. Annexure D. And the second last line, A is here, 37A, is mentioned the proceeding for the post of chairperson. This was for chairperson, and for the member law is in page 38. It starts from 38. May I read that B, proceedings for the post of member law. The committee examined applications of all the 14 candidates for the post of member law. The committee felt that the role of the member law is to actively guide, this is important, my lord, actively guide the work of the commission, which need to be carried on in the accordance with the Electricity Act 2003 and the rules and regulations from thereunder. The committee noted that, this is also important, my lord, committee also noted that Honorable Supreme Court in its order dated 12/4/2018 in the state of Gujarat versus Utility Users Welfare Association, civil appeal number such and such, has mandated that State Regulatory Commission requires a member who has been holding judicial office or a person who has requisite qualification to be appointed as a judge of High Court or a district judge. These are two important, High Court and district judge. Article 233 of the Constitution of India mandates a minimum experience of 7 years as an advocate to be eligible for the post of district judge. The committee therefore consider the candidate who fulfill the following two criteria: a work experience after registration. This is important. One, work experience after registration, an advocate of 7 years or more, experience of working in the state of Arunachal Pradesh. Based on the following criteria, the committee recommended a panel of following 2 members for the post of member law in accordance with the section 85 subclause 4 of the State 2003. 1, petitioner. Second is a respondent. C, observation on the Vigilance Clearance Committee observed that Committee on Arunachal Pradesh is considered relevant vigilance clearance of the candidates who are presently servicing the government department or national bodies. So this was the outcome of the committee, my lord. Now, what happened? This was the outcome. Now, in our submission, this is the list prepared by the expert committee on the basis of the experience submitted by the applicants. And this is on the merit, and if not merit, on the preference, The 2 candidates were selected. So petitioner is number 1 and respondent is number 2. Now, what happened is that impugn, as per the impugn order, I'll just state the impugn order, is page 60. The respondent number 4 was considered without any reason why the respondent number 4 is been picked up, being in number 2, whereas the selection committee should not be doing only the scrutiny of the applicant. The selection committee is constituted of the expert committee, retired judges. It means they have been selected as per the merit, or if not on merit, on the basis of preference. So number 1 is the petitioner. Now, our submission that the petitioner number 1 should have been considered, but then the petitioner 1 wasn't considered, but then the respondent number 4 was considered, and then impugn order was passed. But I'll just take to impugn order, page 64. Page 64, my lord.
Page 60.
Impugn order is merit. Sorry, page 60, sorry. Page 60, sorry. Page 60. May I just take, may I read? 24 April 2023. Please refer to this office order data such and such. Code April 2023, and second para, expenditure shall be debatable such and such. Shall also be read as expenditure such and such. So this is the impugn order, which is passed, my lord, for selecting the respondent number 4, my lord. Respondent 4, my lord. And then I'll just only take out the document we collected from the RTI, and the RTI, I'll just take to page 64. The applicant, this respondent has submitted his experience. It is not reflected in the completed statement, but I will just show you, my lord, page 64. What is his experience? Page 64 is his experience, your lordship may see. Serial numbers, I will just only take 2, 3. Page 64. 7, social activities, such and such. Student of such and such, actually block such and such, 2022. And then 8, president of such and such organization. And then 9 is important, my lord. 9 is practice advocate from 25/6/2020 till date. And other is that this much, my lord. So there is no any practical experience in the district court or in the high court tribunal, any forum of the court. Now, even if as per the act, it says that he should be eligible for the district judge. So now question here is simply enrolling as an advocate. can he be eligible for the district judge? That's also to be noted, my lord. Because unless he has experience in the field, simply enrollment cannot make him become eligible for a district judge. Whereas in this case, simply he was considered because he has got a 7 years as per the enrollment. That is my submission, my lord. And then I'll just take to few of the sections of the Electricity Act. Electricity Act is very clear, my lord. Selection is finalized by the committee, my lord. As per the section 84 clause 3. 84 clause 3 and 5 has to 4 has to be read together. May I just take to 85.4. May I read that one? 85, 3 and 4. I've made it 3 first. The selection committee self-finalize the selection of chairperson and member. It means selection is finalized by the committee. And then 4. And then may I read 4. After the finalization, only the appointment has to be done by the government, because the selection committee cannot appoint. Maybe they have finalized it, but the government has to appoint. Now the statutory provision is very clear. Once the selection committee finalizes it, it has to be recommended. So may I read 4. Selection committee shall recommend a panel of 2 members, 2 names for every vacancy referred to it. So by what I understand is that 2 members means what? It is in the merit list. Selection is finalized. It is in the merit list. If one doesn't go for the appointment, then if one is not available, then second may be considered. There could be the interpretation. That's my understanding. Your lordship may interpret that way, but my understanding that one, because finalization is done by the selection committee. That is one. And another I want to point out is 84, section 84 also very important. Section 84. Section 84 clause 1. Qualification for appointment of chairperson and members of the state commission. May I read clause 1. Chairperson and a member of the state commission shall be a person of ability, integrity, standing, who have adequate knowledge. My lord, may not have adequate knowledge or have a shown capacity in dealing with a problem relating to, I will not read other parts, relating to the law. So he should have adequate knowledge and have shown a capacity to deal with the problem with the law. It means if I see the experience, the petitioner has got wide experience, 20 years of experience. He has a wide knowledge than respondent for. So it is obvious that the selection committee must have considered him as a number 1 on the merit, or if not on merit, on the preference. He should have been considered as a member of law. That is one. And then another thing is that 3, clause 3 also very important. Clause 3, it says, chairperson or any other members of the state commission shall not hold any other office. Shall not hold any other office.
Which is the provision which provides for State Electricity Regulatory Commission?
Sorry?
State Electricity Regulatory Commission. Which is the provision which provides for State Electricity Regulatory Commission?
At 82, sorry, 82.
Huh?
82.
82.
Yes. 82 talks about constitution of a state commission. And I will read subclause 4 and 5. Subclause 4 talks about the state commission shall consist of not more than 3 members, including the chairperson. And then 5, chairperson or member of the state commission shall be appointed by the state government on the recommendation of a selection committee referred to in section 85. So this is the legal provisions. And then I'll just take to the my own affidavit rejoinder.
Yes.
Yes, may I take to my own rejoinder? We filed rejoinder to counter affidavit filed by the first respondent number 4. So they have taken the issue of office of profit. That is one. Another is their issue was that he is holding as a standing counsel and retainer. That is their allegation. But then I want to take the advertisement of for the chairperson.
You are now arguing their case.
No, I'm my own counter affidavit. My rejoinder.
Rejoinder.
My rejoinder. My rejoinder. Just I want to just only show one document.
So you say your case is that despite you being in number 1, you have not been appointed.
Appointed.
That is your case.
That is my case.
What do they say in their affidavit, counter affidavit?
Counter affidavit, my say that their main especially the state respondent has no issue on the office of the profit, but the only respondent 4 has taken the issue of office of profit, saying that he should be disqualified. He should have been qualified for the appointment. He should not have his application should not have been entertained because he was holding the office of the profit. Now I want to show is that the person who was the petition was having a standing counsel of that Arunachal Pradesh Consumer Cooperative Federation Limited. Is
office of profit a disqualification? Oh,
that's what their argument. So I want to just only show one document, page 11 of my rejoinder, page 11.
what is that?
Page 11 is advertisement for chairperson. So it suffices everything, madam. Page 11. Page 11.
Yes.
Page 11, yes. Page 11 is an advertisement for the chairperson, and the relevant serial number is 6. Married. Person appointed would have to resign or opt for voluntary retirement from the service to which he or she belongs. It means, suppose if when he was applying an application before the authority, if he was holding office also, once he is appointed, he can resign. So same has been this is advertisement for a chairperson. So same this
Any qualification prescribed
yes, madam.
for member? Eligibility criteria, educational qualification, disqualification.
That is only as per the Electricity Act, madam. It's only Electricity Act.
Any qualification prescribed?
Only law degree should have experience to become a High Court judge. One, it is one.
Where
Yes,
where it is?
yes, madam.
Qualification for appointment of chairman and members, 84 of the State Commission.
I think may I read the 84?
Yes.
Yes, my lord, as for the advertisement, they have not mentioned, they have only the serial number 8.
Who is
Did you-
asking you about the advertisement?
No, I'm talking about the
We have seen the advertisement.
minimum qualification is a law, and he should be eligible for the High Court judge, and second is for the district and session judge. That's all.
Member.
Members.
Where it is provided?
My lord, I may take to the, yes, I will just, I'm missing this provisions, there's somewhere provisions.
Anyway, you leave it there. If you are missing, you're missing.
Yes, it is, I will just,
Yes.
I will come back to that provision, my lord.
No, you will not get further chance. You have to complete your argument.
Yes,
At
my
one go. Okay, all right.
Okay, but that is one ballot. And then as for the judgment, in fact, before that, the petitioner will not cover under the office of the profit, because even if we presume that he is the standing counsel of the.
Where is the requirement of office of?
No, in fact,
Huh?
anyway, that I will reply after their reply. In fact, I'm just submitting of their counter affidavit, my lord. So I will just finish my argument, and then after their submission, I may reply to that one, my lord. Now I will just take to the. I'll just in supporting with the judge, supporting with the act. Who can be appointed, who should be eligible as per the judgment? I'll just read one of the judgment.
As per the judgment.
I'll just read the judgment, especially para 18 in para 121. Because this judgment also been referred in the minutes of meeting by the expert committees, my lord, that who can be appointed as a member. So I will just take to 118, 18, 21, 25.2. I'll just read first 18, 118 para. We are thus of the view that it is mandatory to have a person of law as a member of state commission. When we say so, this is very important, my lord, it does not imply that any person from the field of law, 118, page 118, paragraph 118.
Yes.
May I read 118? 118, may I read? We are thus of a view that it is a mandatory to have a person of law as a member of the state commission. When we say so, it doesn't imply that any person from the field of law can be picked up. This is, my lord, this is also very important, my lord. It has to be a person who is or has been holding a judicial office, or is a person possessing professional qualification with substantial experience. My lord, I'm trying to differentiate with the respondent of 4 is this.
You read, Mr. Mao.
Yes, my lord.
Thereafter, you make your submission.
Yes, yes. Substantial experience in the practice of law, who has the requisite qualification to have been appointed as judge of High Court or a district judge. And then may I take to para 121. We are thus of the unequivocal view that for all the adjudicatory function, because this is the adjudicatory function, para 121. 121.
Yes.
Married. We are thus of the unequivocal view that for all the adjudicatory function, the bench must necessarily have at least one member who is or has been holding a judicial office, or is a person possessing professional qualification with substantial experience in the practice of law, and who has the requisite qualification to have been appointed as a judge of High Court or a district judge. And next paragraph I will want to take is 125.2 and 125.3. So I will just read 125.3. 125.3. That in any adjudicatory function of the commission, it is mandatory for a member having the aforesaid legal expertise to be a member of a bench. So now, as per this judgment, what I understand is para 18 is that the person should have professional qualification, that is okay, but the substantial experience is very important, madam. Substantial experience in the practice of law. So this must have been considered by the selection committee, and accordingly the petition has been placed in number 1. This is also mandated by this statutory provision. So this is
regarding the chairman.
No, for the members also, my lord. For the members also, my lord. For members also, my lord. Chairman's background is not a legal requirement. Only the member law.
Huh?
One member law. For member law. Because the specific they have mentioned member law. So member law means he should have substantial experience in the practice of law. So in my case, the petitioner has got 20 years of experience in the different field of court, standing in the law court and the high court. Even if I ask myself, the selection committee will obviously consider the applicant who has got better experience, who has got length of experience, and now the petitioner is eligible for even for the High Court judge under Article 217B.
Right. You are more knowledgeable, more experienced.
Yes, that's what I meant.
More competent than
More competent, which is also required by the Act provision. Also required by the Act. That's one. And now, my lord, as per the counter affidavits, they talk about the discretion, saying that the state government has got a discretion to select anyone from the recommended person. I want to just place some of judgments, which I want just only only 1-2 paragraphs, which talks about the prerogative. As per we file RTI, and the RTI, what we have asked is that on what ground the respondent number 4 has been considered. Now their replying is say that it is a prerogative of the government. That's one. Now in the counter affidavit, they said that it is a discretion of the government. That is only the argument the state government has got.
Yes.
On a discretion and a prerogative. No, I want to just place a few judgments on prerogative and discretion.
Yes.
Two thousand four, volume 2, SSC 590. Para 20, my lord. I just read para 20. May I read para 20? 590.
Yes.
Para 20, may I read?
Yes.
When anything is left to any person, judge or the magistrate ought to be according to his discretion. The law intends it must be done with sound discretion according to law. In its ordinary meaning, the word discretion signifies unrestrained exercise of choice or will, freedom to act according to one's own judgment, unrestrained exercise of will, liberty or power of acting without control other than one's own judgment. But when applies to a public functionaries, my lord, it means a power or right conferred upon them by law of acting officially in certain circumstances according to the dictates of their own judgment and conscience, uncontrolled by the judgment or unconscience of other. Discretion is to discern between right and wrong, and therefore whoever had the power to act at discretion is bound by the rule of reason and law, my lord. Should be bound by rule of reason and law.
Yes.
So when they say that discretion, okay, if they have picked up number 2, then there must be some reason. There must be which support that on what ground they have, on what reason they have picked number 2. That is one, my lord. And another judgment I want to place is
Okay, we'll come back at 2.
okay, my lord. Listen.
I'm sorry, my lord, this morning I missed to mention, item number, my lord, 2021, my lord. The transfer matter, my lord. So, my lord, as per the instructions received from my client, my lord, I may be allowed to withdraw, my lord.
Okay,
I'm for responding.
right?
Maybe, my lord, he wanted to comply,
All right.
my lord.
21, 22. Mr. M. Kato and the council for the petitioner.
My lord, for the petition.
And T. Zamok, T. Tagumpo,
For private respondent.
number 4.
Madam.
Okay, sir. Mr. Kato, who is for the government?
I remember.
Kato,
I remember.
council for the
Madam,
petitioner.
I'm sorry to say, madam, I'm for respondent 6 months.
Six.
Private respondent.
On instruction 6 to withdraw this writ petition. The writ petition is then dismissed on withdraw. Interim order passed earlier is since vacated.
My lord, another matter, with a liberty to file a fresh if so advised, my lord.
Challenging the same transfer order.
No, my lord, in fact, it's because, my lord, some documents has been sought for that has also been not furnished with, my lord. So, my lord, that may not be possible. But then, my lord, at least that,
Now, how can you permit you to file
no, my lord,
fresh writ petition challenging the same order?
no, my lord. With a liberty to file a press if so advised, my lord.
But not challenging the same transfer order. Will be liberty?
Although there's no issue, but the entire matter is on withdrawal. It's
Just to save the skin, otherwise, my lord, there is nothing, my lord. Well,
You'll approach again? No.
my lord.
Okay, we'll grant liberty.
Yes, ma'am.
But why should we grant you liberty?
My lord, if so advised, my lord, to,
See, transfer order is under challenge.
my lord.
We have substantially heard on that matter. Is not it? And
So
then
therefore, my lord, I sought for the, my lord, to withdraw as instructed by the madam.
we can grant you liberty to file a press writ petition challenging any order other than this transfer order.
for that, madam, liberty need not to be given. Madam, because it have a separate.
My lord, otherwise, my lord, also, my lord, if liberty is given, my lord, there will be no prejudice to the petitioner, my lord, the private respondent.
But you will be wasting the court's time
Admittedly, my lord, but my lord,
and the time of the registry.
my lord,
You know how many people are involved in the registry handling your case file so that it reaches the court.
my lord, that is one aspect, my lord. Admittedly, my lord.
All right, with liberty. Huh? Oh, all right.
My lord, may I mention item number 13 and 12.
I also dispose of. Huh?
Item number 12 and 13, my lord. In this matter, my lord, I am not come with the brief. So therefore, just now I have checked, my lord. I am for the petitioner, my lord, also the respondent, Union of India, my lord.
12 and 13.
My lord, I have taken the consent of the other party, my lord, Mr. Opada, for the petitioner in the border cases.
Okay. When do you want?
My lord, after
When do you want the matter?
a week, my lord.
So why after a week? This, I don't know, 12.
My lord, 12 and 13, my lord. My lord, since the counsel for the petitioner is present, my lord. Any appropriate date suggested by him, my lord.
What is the matter about 12 and 13?
My lord, it pertains to, my lord, payment of compensation, my lord.
Land compensation. Yes.
12 and 13. admission.
Affidavit is filed.
Is the government has filed.
No. After 3 weeks.
My lord.
After 3 weeks.
Diploma.
On the prayer of Rato.
Very good afternoon, my lordship. Your lordship, if I may, the petitioner advocate for item number 5, item number 6, item number 7 and 24 is regrettably not at station. So therefore, your lordship, I pray for granting adjournment for the matters mentioned. Thank you, your lordship.
5, 6
7 and 24.
and
Items number 5, 6, 7 and 24.
24. After 4 weeks.
4 weeks, yeah.
Okay, after 4 weeks. You are Mr.? You are Mr.?
Tony
Your
Pat-
good name?
Tony Patin. My name is Eddie Pai. I'm on behalf of Tony Patin, petitioner advocate Tony Patin.
Tony Patton is appearing for the petitioner in all the case.
Yes, my lord.
Okay, all right. Yes. after
Thank
four.
you. Thank you.
Item number 14 and 17. Matter may be adjourned.
14 and 17.
17. In the 14, I am the respondent, on the 17, I am the petition. I have taken consent from the practitioners.
When do you want?
Maybe it's after week. I have some urgency that is why. I have to go somewhere.
Okay, after 4 weeks.
Yes.
Okay, 14 and 17.
14 and 17.
Okay.
My lord, may I plead, my lord? May I placed 3 more judgment, my lord. One is on discretion, another is on prerogative, and third is on the office of profit.
Yes.
I have given a list of the books. Citation is, my lord, 2004.
You only place the relevant
Yes.
decisions.
Yeah, relevant.
Not all the list of books which you have given.
Yes, only relevance.
Yes,
2004, volume 2, SSC 370.
that is for what?
This is on discretion.
Discretion.
Yes, my lord.
Page,
Paras 9 and 10.
Discretion, you have already placed one judgment.
Yes, but I want to play this one also. Okay.
2004.
The one
2
with
SCC.
page 9 and
590.
page is
place.
325 and 375. Married, my lord.
Which one?
This
Yes.
2004, volume 2, SSC 370, paras 9 and 10. Para 9 and 10. May I read para 9 and then we'll go back to para 10. May I read? Discretion is in general is the discernment of what is right and proper. It denotes knowledge and prudence. That discernment which enables a person to judge critically of what is correct and proper, united with caution. Nice discernment and judgment directed by circumspection, deliberate judgment, soundness of judgment, a science and understanding to discern between falsity and truth, between wrong and right, between shadow and substance, between equity and plurable glosses and pretenses, and not to do according to the will and private affections of person. When it is said that something is to be done within the discretion of authority, that something is to be done according to the rules of reason and justice, not according to the private opinion, according to law and not humor. It is to be not arbitrary, vague, and fanciful, but the legal and regular. and it must be exercised within the limit to which an honest person, honest man, competent to the discharge of his office ought to confine himself. Para 10 merit. The word discretion standing single and unsupported by circumstances signifies exercise of judgment, skill, and wisdom as distinguished from fully unthinking or hazard. Evidently, therefore, a discretion cannot be arbitrary but must be a result of a judicial thinking. The word in itself implies vigilant, circumspection, and rare. Therefore, there must be a legislature concise discretion. It also imposes a heavy responsibility. Now, as per the RTA, they also rely on they say that the decision selecting of the respondent was prerogative of the government. So I want to just place read the paragraph 14 of SSC 2012 SSC volume 3 117 paragraph 14 2012 volume 3.
That is for what proposition?
This is for a prerogative.
2012.
Yes, 2012 volume 3. Page 117.
Yes.
And relevant paragraph I want to read is paragraph 14.
Yes.
May I read the paragraph 14? We are of the view that the expression prerogative cannot be used in the context of a statutory provision. Because this, and under our constitutional and statutory framework, there is nothing known as a prerogative. In this connections, we may usefully recall what was said by the eminent jurist, such and such in his treatise of our constitution, deface and defile. May I read that paragraph, down paragraph. Our constitution recognizes no prerogative whatsoever. It recognizes merely rights, duties, and discretion. The difference between the prerogative and discretion is clear. A person who has a prerogative can act arbitrarily or irrationally, yet his discretion must be treated as a legal valid. On the other hand, if a person has a discretion and not the prerogative to make a decision, discretion can only be exercised fairly and reasonably. Otherwise, his act is void on the ground that there was no valid exercise of discretion in the eye of law. We are in respectful agreement with his view. In this case, the court is not changing any public prosecutor who has already been appointed. The question in the present case was never an issue. In such a case, therefore, the decision of such is not much relevant here. So this is on the prerogative alert. And another last I want to refer is that on this office of the prophet, because they are also harping on the office of the prophet. It's 2001 volume 2 page 119. Volume 2 page 19. Relevant paragraph I want to read is 6, 7 and 14. May I read para 6? May I read? The phrase office of prophet is not defined in the constitution by a series of decisions. Since such, this court has laid down the test for finding out whether the office in question is an office of prophet under the government. These tests are: 1, whether the government makes the appointment; 2, whether the government pays the remuneration; 3, whether the government pays the remuneration; 4, what are the function of the holder? Does he perform them for the government? And 5, does the government exercise any control over the performance of those functions? Para 7, Malad. In the Guru Govinda Vasu versus Sankari Prasad Ghoshal, the constitution bench emphasized the distinction between the holder of an office of profit under the government and the holder of the profit, holder of a post or a service under the government, and held that for the holding an office of profit, under the government, one need not be in the service of government, and there may be no relationship of master and servant between them. Several factors entering into determination of questions are appointing authority, the basic authority with the power to terminate the appointment, the authority which determines the remuneration, the source from which the remuneration is paid, the authority vested with the power to control the manner in which the duties of the office are discharged, and to give directions in that behalf. But all these factors need not coexist. Mere absence of one of the factors may not negate the overall test. The decisive test for determining whether a person hold an office of profit under the government, the Constitution bench hold, is the test of appointment. Stress on the other test will depend on the facts of each case. The sources from which the remuneration is paid is not by itself decisive or material. My lord, I will just take to another paragraph, is paragraph 14.
We'll look at it later on.
Yes, madam. I think
Office
that,
of profit.
okay.
Yes.
I think that much, my lord. So in my case, the petitioner basically also not holding an office of profit, because what their allegation was that he's having an office of profit. The where he was a standing counsel, he's no more, as per the official order, there's no more. He's a standing counsel. Only he has been paid the case basis. So he has been paid on the case basis. That is as per the RTA reply. So he doesn't hold an office of profit. So in my case, my lord, it's the my prayer is that it is the case where your honorable court should interfere the impugn order and issue appropriate directions to consider his case, as the impugn order was first arbitrary in the violation of the statutory provisions of the Constitution, and then the statutory provision, the Constitution of India, and then the statutory provision, the Electricity Act 2003. So that is my case, my lord. So your lawsuit may interfere the impugn order, and this may be
All right.
case. That much unnecessary, I may reply. That much.
No, my lord, as per the order of His Honorable Court on 9/6, the issue of maintainability is to be decided at the first instance before going into the merit, because that issue was raised by me in the affidavit filed by, I'm representing respondent number 4. Lordship, have a look at the order of 9/6.
Yes. Yes.
Now, the issue of maintainability is raised because your lordship may come to section 84 of the Act, which prescribes qualification.
Yes.
Now, 84(3), the chairperson or any other member of the State Commission shall not hold any other office. Now, my lord, there is a difference between holding an office and holding an office of profit. My friend is hoping that holding of office of profit is not required. Yes, true. It is the holding of an office which is a bar. It is not a holding of office of profit. Now, this is a qualification, to my understanding, which a candidate should meet before he is selected or before his application is taken up for consideration. Now, my lord, will have a look at the judgment of this honorable court.
Chairperson or any other member of the state shall not
Hold any other office.
any other office. If he is appointed, he will not have,
No,
not hold office.
my lord, this is something qualification for appointment.
So
Ah.
if the statute says it is a qualification for appointment, then my understanding of this provision is this is something which a person has to meet before he is appointed.
Okay.
And his appointment is be subject to recommend.
He was offered an offer of, offer of appointment.
No,
Then how will he know that he is going to be appointed?
my lord, my understanding qualification for appointment. Now statute is prescribing a qualification for appointment. Now this appointment is preceded by a selection process. So during the selection process or at the time of submission of the application, he must meet this qualification. If any qualification is prescribed. If a person is holding an office,
There is no such prescription in the advertisement.
my lord, it is the statute, my lord.
No, but he could not have known at that point of time that he is not required to hold any office.
He could not know, but my lord, if the advertisement is, which one will prevent? The advertisement or the statute, which prescribes the qualification?
Qualification for appointment.
Yes,
He is yet to be appointed.
my lord, if he is,
Denial of appointment is on that ground.
my lord,
Denial of appointment is on that ground.
my lord, denial, it is not the denial of appointment. It is the question of whether he could have been considered or appointed.
He
If
was not considered on this ground.
no, that is why we have raised this question that if he is not qualified to be appointed, then can a writ at his instance is maintainable?
Does the appointing authority say so that he has not been appointed because he is holding
No,
any other office?
no.
Then
If the, it is not the appointing authority's view is that, but my submission before a lordship is, this is something which he ought to have met before his case could have been considered for appointment. So under the
No,
statute,
he was unaware of any consideration by the state authorities until the private respondent was appointed.
so his writ petition is challenging the appointment of the respondent number 4. Now, my submission before a lordship is a person who is not qualified to be appointed under the statute.
Okay.
Can he question the appointment of a person who has been rightfully or legally recommended by the selection committee? Why I am saying so, my lord? Lordship will look at the judgment, the record, it is in the record, where this honorable court has examined the question, what would amount to holding an office?
Which one?
This is there, I have given on the very first day. That is a case of Mukpartin versus Lombotayang, 2015, 3 GLT.
Standing counsel.
Standing counsel.
Standing counsel is the office of profit.
No, my lord. Here the word is not office of profit. Here the word is holding an office. There is a difference between holding an office and holding an office of profit.
Standing counsel is an office.
Yes.
So since he was holding an office, he was ineligible for appointment.
Yes, he is holding an office as standing counsel, legal retainer of APCCF, Arunachal Pradesh Consumer Cooperative Federation.
Arunachal Pradesh Consumer
Yes.
Cooperative Federation.
My lord may come to page 709, paragraph 28E.
No, that is an office.
He is holding an office.
Yes.
Now, my lord, in the affidavit, in reply to the affidavit, he has made a false statement. Lordship would like to look at the statement which he has made in that affidavit. Now, my lord may come to page 6.
6 of
His affidavit in reply
to my affidavit. Page number 6.
You are respondent number 4. is not it?
Yes, in reply to the affidavit of respondent number 4, perhaps it was filed on, I do not know, but a
Yes.
copy was served on 29/6.
Yes.
Page number 6, last but one line.
Number 6.
It is pertinent to mention that petitioner is no longer serving as standing counsel or retainer of the federation, as earlier appointment dated 15/3/2018 for 3 years expired before the application was filed.
Paragraph?
6. Page number 6, it is paragraph 6. And yes, paragraph 6, but what I am referring, your lordship will find at page number 6.
Paragraph number 7.
Paragraph number 7, page number 6,
Page number
the
6.
last but one line. It starts from.
It is pertinent.
Yes, to mention the petitioner is no longer serving as standing counsel or retainer of the federation, as earlier appointment order dated 15/3/2018 for 3 years expired before the application was filed. Now, this is totally a false statement on oath by a petitioner seeking equitable relief from this honorable court. Why I am saying so, lordship will have a look at the affidavit in reply, which we have filed. On 17th. Lordship may come to page 42 of my affidavit in reply.
Affidavit in reply.
Filed on 17/7. Page number 42. Now, this is
No, I am yet to locate your affidavit in reply.
perhaps the last one.
Huh?
I have checked, it is there in the record.
Last one. This is an additional affidavit.
Yes, my lord. So I am sorry, my lord, additional affidavit.
Oh, yes.
My lord, this is additional affidavit, page 42.
Page 42.
Yes. This is the document which I got in response to an RTI application from the Federation, showing that from the date of his engagement in 2018, he is receiving salary. Stroke honorarium. Now, last January 2023, he received 5,000 as salary. Honorarium.
Page 42.
42.
Hmm,
January 23.
January 20.
Last.
Yes, January 23.
My lord, if your lordship continues, then I won't trouble your lordship by.
Have you filed a reply to the additional affidavit?
Yes, my lord. We have filed earlier additional affidavit filed by them. We have replied.
You have replied.
Yes, my lord.
What is your reply to this, that you have received honorarium for the month of January?
Yes,
2020?
but this one, my lord, reply is in their reply, counter affidavit only, my lord.
Reply
I will
is
just-
in their reply.
I will just take to that document, my lord. Annexure 1.
No, he is making an allegation in the additional affidavit file. That
No,
you.
I'll just take to my own affidavit.
No,
No, in fact, they have served yesterday only.
Okay.
So we have not replied to that, but then I will just take to.
Would you like to reply or not?
No, in fact, I will try to submit, my lord. Why?
No, see, shall we go ahead with the hearing? See, court has no issue.
I'm not denying, my lord. What about he's saying, it's the honorarium, it was based on the case basis, which I want to show in that their own annexure reply by the concerned authority is the page 8.
So you are still a standing counsel.
Yes, not standing counsel, my lord. It is reply, my lord. I'll, because my standing counsel was till 15.
Then for what purpose you have been paid honorarium for the month of January 2023?
No, my lord, not only January, up to June 2023, page 46. Even after filing of his reply, lordship may come to page 46.
My lord, I'll just take to his reply para page 8, my lord. Page 8, serial number 5, which is replied by the
His
counter affidavit. Additional affidavit, my lord.
additional affidavit.
Yes, my lord.
Additional affidavit?
Additional affidavit filed by the respondent 4.
Yes.
May I take to page 8, annexure 1,
Page 8.
annexure 1.
Yes.
Yes, my lord. To 5, my lord. 4 and 5, my lord. I will just take to. Yes, 3. Para 3, I will just read. Copy of extension order issued to the budget for the post or legal constituent. No extension was made. As such, there is no appointment order after the expiry of 3 years as in 15/3/2021. And then
See, Mr. Mao.
Yes,
This is a reply. So this is an information furnished to respondent number 4.
Yes.
Pursuant to the RTI application filed by him by the.
Yes, my lord.
By the
Managing director.
PIO.
Yes, my lord.
Okay, PIO.
Yes.
Now, what is what the respondent number 4 is alleging is you have filed a false affidavit. That is what is the allegation that your appointment as a standing counsel in the 2018 was for 3 years. And it expired after 3 years. There were no extensions.
No extension.
Which means 1920 to 21.
Yes.
In 21 it expired.
Expired, my lord.
This is your statement.
Yes, my lord.
Now he is making an allegation that you have, by filing an affidavit to that effect, you have filed a false affidavit on oath.
No,
And-
we have.
Huh? So therefore he is showing this page 42 of the additional affidavit filed by him, where it is shown that you have received honorarium for the month of January 2023, which indicates, according to him, that you are still a standing counsel. So it is for the limited purpose that you have filed a false affidavit.
My lord,
Whether it is maintainable, not maintainable, we'll take a call. Huh? So, but there is an allegation coming from his side that you have filed a false affidavit.
And which is an offense under section
So-
193 IPC.
So despite that, if you would like to proceed with the hearing, we will proceed with the hearing.
my lord, para 5 also, my lord, may see also.
No, first you have to tell us that shall we proceed with the hearing or not? Because on the face of
Then,
it,
my lord, we may give it.
if you do not deny it, his allegation of filing false affidavit by you perhaps will remain on record. I don't know what bearing it will have on the merit of the case,
My lord, in fact,
but that much will remain on record.
yes, my lord.
Okay, yes, proceed.
My lord, lordship has taken note of the fact that he was appointed on 15/3/2018 for 3 years.
Yes.
Now, lordship may come to page 46. It says that he received salary honorarium up to June 2023. Page 46.
This is an RTA information.
Yes, this is the big bunch which I got in reply to my RTI application.
Now, this June 23, he received salary of 5,000. Page 46. Now, my lord, if by his statement, his appointment for 3 years on 15/3/2018 expired on 15/3/2021. Lordship may come to page 48. This is a wakalatnama of a case in which he appeared on 23rd December 2021, representing 1 and 2.
File loan,
File on, this is the wakalatnama.
file loan.
On that day, because he entered on the next page, page 50 is the order passed by these honorable courts in that petition. Lordship may come to page 52. Mr. D. Boje, learned counsel, has entered appearance on behalf of the respondent number 1 and 2. That is an order passed on 22/12/2021. Then in the same case, your lordship may come to page 54. That is an order passed by your lordship. Heard Mr. D. Boje, learned standing counsel for the Arunachal Pradesh, Standing Council Arunachal Pradesh Consumer Cooperative Federation Limited, responding number 1 and 2. That is on 25/2022. Then my lord may have a look at the order passed on 8/9/2022 in the same matter, where Mr. D. Boje, that is the red petitioner, learned counsel for the respondent, made a prayer for filing affidavit in opposition in the matter. 8/9/2022. So, my lord, my respectful submission, my lord, this is a statement made by the petitioner on oath, which is a blatant lie. He received wages or salary up to June 2023. The application in terms of the advertisement was submitted on 22/7/2022. On that day, my lord, he was representing, he was a standing counsel, because on the order of 8/9 clearly shows that he is representing the department. And my lord will appreciate one thing in his appointment letter, which your lordship will find at page
'Because the counter affidavit was submitted, we were served yesterday. So, my lord, maybe we will file by tomorrow, and matter may be taken as part heart, maybe day after tomorrow.
It is too late in the day to say so. I have asked you categorically twice.
In fact, I have to take instruction from the.
So you did not pray for that also. You have to take instruction from your client.
my lord may come to page 34 of the red
We
petition.
have already proceeded.
Now,
Because they also delay in serving. We will file by tomorrow.
tomorrow,
In that case, my lord, it has to go to 7th. And we have been patiently, I take back only for this matter.
List it on 7th into annual filing of reply to the additional affidavit filed by the respondent number 4 by the petitioner.
Maybe taken as a part heart matter.
Not partner. I have never kept any case partner.
Like.
Huh? 7th August.
7th of August. Like.
Yeah, my lord, government, affidavit from the government is necessary. Regarding this payment of contractual bills, part payment has been made.
Yes. Mr. S.K. Devi, what is your prayer?
No, Lordship.
Can it be disposed of? You pay,
Lordship. Appeal is doing this matter.
huh?
Senior command advocate is doing this matter. I don't have that brief also.
Where is he? On the prayer, had Mr. S.K. for the petitioner, on the prayer, and Ms. G. At the additional senior government advocate. For the state who prays for any granted 4 weeks time to file counter affidavit.
Let it be, my lord, 2 weeks.
List it after 4 weeks. This is what? Hill transport subsidy?
Yes, my lord.
6 weeks.
Let it be 4 weeks.
Huh? Okay,
4 weeks. Apply. Sir. May I, my lord?
Yes.
My lord. Sorry, my lord. I put the respondent number 6 in item number 8. My lord. I need some time to file affidavit in opposition.
Yes. What is the matter, Ramo?
Matter is about, my lord, challenging the line allotment order.
Land allotment.
Yes, sir.
How much time you require?
3 weeks. Time, my lord.
3 weeks.
Yes, my lord.
Hard miss. We'll grant time to him to. Yeah, good name.
Margam Basar.
Hard MS Margam Basa, legal counsel for the petitioner. GAT is also there.
Yes, sir.
Have you filed? Okay. GAT, an additional senior government advocate for the state who submits that the counter affidavit by the state has been filed. Mr. P. Tagu, learned counsel representing respondent number 6. Press for and is granted further 3 weeks time to file counter affidavit. Listed after 3 weeks.
Watch your place.
May I please, ma'am? Yes, my pleading is completed, ma'am. So matter may be fixed in admission hearing, ma'am.
What is the matter about?
Matter is about challenging the legality and validity of order issued by the EAC Kai.
तो हवा को ऊपर फेंकने के लिए बोला था। नहीं सुनो, पहले तुम समझे कि नहीं समझे? बात को नहीं समझ के वापस मत जाओ। अभी क्या समझे? क्या कैसे? काम में फेंकने दो। हाँ? काम में फेंकने दो। ऊपर फेंकने दो। Yes.
Yes, madam.
Matter may be fixed for admission hearing. Lordship. We have already filed our.
Pleading is completed, madam.
What is the matter?
Matter is about challenging the legality and validity of the order issued by the EAC Kai, madam.
Lordship. Kebang.
Without jurisdiction.
Yes, madam.
What do you say? Listen to admission hearing.
Yes, madam.
Yes.
Oh.
So I will post.
What, Mr.
Dia the madam.
You are the counsel for the.
Petitioner.
If you are ready, we can hear the matter.
No, maybe.
Admission order, what? How does it make a difference? Yes.
No, my
Petitioner and Ms. G. Additional senior government submits that the counter affidavit by the state have been filed and press for listing of this matter for admission hearing. Was as per for listed after 4 weeks for admission hearing.
Yes. Much.
Thanks.
My lord, I may be allowed to file additional affidavit in both IA and the main petition, my lord, because in the pendency of this petition, my lord, there has been subsequent developments as verbally instructed to me.
What is the matter about?
Yes.
What is the? You have got the respondent.
Yes, my lord.
Which respondent?
2 and 3, my lord.
Is tourism department.
Yes, ma'am.
What is the matter about? What is the matter about?
Lord, I have put on challenge, my lord, order that impugn order, my lord, whereby, my lord, I was transferred with a post, my lord.
Along with the post.
Post, my lord. A place where there is no post, my lord.
What kind of a subsequent development has taken place?
My lord, I have been verbally informed that the petitioner has been placed somewhere in the secretariat, my lord, not in Upper Siang Yingkiang, my lord, where she was transferred.
Yes. Are you in secretariat?
And I'm not sure, my lord.
Then. What is the transfer order?
Page number 20, my lord.
20.
Sorry, my lord, it is at 18, my lord.
18. Oni touching. With post.
Serial number 4, my lord.
Yes.
I am at serial number 4, my lord.
How have they justified? How have they justified in the affidavit file?
Why they are they are saying simply saying they can do so, my lord, without any making any provision or any law. They are simply saying they can do so.
You will set it as a
Pardon, my lord.
will allow the petition?
No, my lord.
Because according to your instruction, petitioner is somewhere in the secretariat. He is not required to be there in Inkyong. And since 2020,
Yes,
he has been enjoying the stay order.
my lord.
And I don't think you can transfer anybody along with the post.
My lord, I don't have even the counter affidavit filed by the tourism department, my lord, because prior to my appointment, this was represented by the GA, my lord.
Very well. Which is the paragraph where they've said?
Para 10, my lord, page number 5, my lord, of the affidavit filed by respondent number 3, my lord.
Yes. Can they not do so?
Yes, my lord, my humble submission, I'm raising a legal issue, my lord, here. Now, creation of post, my lord. My lord, no, my lord, creation of post, my lord, involved, my lord, decision by the government, my lord. Decision, now, this transfer with the post, my lord, was done under only under the instruction of my lord, department only, my lord.
When were you appointed?
I have, my lord.
2003.
My reason, my lord, basically, I'm saying, my lord, this creation of post, my lord, involved normally in terms of the business rule, my lord.
1996, it was
Yeah,
created.
my lord.
Okay. How
Business,
this-
it involved the concurrent of the finance department, my lord.
how
Now-
this Help permanent counsel for the petitioner. Mr. And Pada, standing counsel for the tourism department representing respondent number 2 and 3. I rewrong. Have you filed affidavit?
No, Lordship.
I rewrong on additional for 1 and 4. Non. Where is it? 5 is yet to be served. Who is 5? Oh, yes, yes. First, none has appeared. Correspondent 5, this was service of notice as indicated in office note dated 15/7/2023. This reputation is directed against the order of transfer dated 16 June 2020, issued by the Secretary Tourism Government of Arunachal Pradesh by number so and so at page 18 in so far as the petitioner and the respondent number 5 is concerned. However, the petitioner who is an assistant in the Directorate of Tourism Itanagar has been transferred in the office of the DTO Tourism Yingkiong along with the post. And in her place, who has been brought in? Serial number?
7 minutes.
And in her place, the respondent number 5, who is an LDC, no? LDC, Law Division Clerk, in the office of DTO Tourism Yingkiong, has been brought in by posting the respondent number 7 at the Directorate of Tourism, Itanagar. The contention of the petitioner is that the petitioner was appointed as assistant in the Directorate of Tourism, is not it?
Yes, madam.
By an order of appointment dated 19 August 2003, issued by the Secretary of Tourism, Government of Arunachal Pradesh by number source at page 16.
16 minutes.
Huh?
Pardon, madam.
No, page 16. In a post. No, not in a post. Which post was created? This order has been issued by whom? Page 15, post creation order.
Post.
You have annexed the incomplete document. Which post was created by the government? On 12 by an order dated 12 July 1996. By number POU. Would you make ESTT 88/95 at page 15. Whereby one post of assistant was specifically created for the headquarters, which is the Directorate of Tourism. Eternal. Full stop. Though the order dated 12 July 1996 and you say that annexure 1 to the writ petition, huh? Though the order dated 12 July 1996, annexure 1 to the writ petition, whereby it has been contended to have created one post of assistant for the headquarters by the government, does not contain the author of the order. The respondent, the respondents 2 and 3 in the counter affidavit file have, however, not denied that that one post of assistant was created by the official order dated 12 July 1996 for the headquarters, which is the Directorate of Tourism. Full stop. In view of the above, the petitioner contends that since he has been appointed as assistant in the post created for the headquarters, which is the Directorate of Tourism, by the order dated 12 July 1996 by the government, the petitioner could not have been transferred elsewhere along with the post. He could not have been transferred to the office of DTO Tourism Linkyong along with the post. Full stop. The respondents 2 and 3. No, respondent 3 has filed a counter affidavit where in paragraph 10 of the counter affidavit file, it has been stated that transfer of an employee along with the post to other district in the same department no policy decision is required, and it can be no policy decision required since it is purely an executive and administrative matter. Full stop. The department can do so in public interest and administrative exigency. Full stop. Apart from stating as above, the respondent number 3 has not indicated as to how the executive has not indicated the basis and or as to how by an executive decision the executive can transfer the post created for the particular place to elsewhere along with the personnel. In the absence of any explanation provided by the respondent authorities, the very basis on which the post created for a particular place can be transferred to elsewhere and inclined to accept the contention of the petitioner that the post created for a particular place cannot be transferred along with the person to any other place by the respondent authorities. Also, in the instant case, the petitioner is found to have been appointed as assistant on 19th August 2003 in the Department of, in the Directorate of Tourism, no? Directorate of Tourism, Itanagar, in a post created by an order dated 12 July 1996. Specifically for the headquarters, which is Directorate of Tourism. And in that view of the matter, I am of the view that
My lord,
the
sorry, my lord,
petitioner could not have been transferred to the office of DTO Yingkyong, Department of DTO Yingkyong, along with the post of assistant which was occupied by the petitioner in the Directorate of Tourism, Government of Arunachal Pradesh. So accordingly, the impugn order written.
may I submit a few line, my lord?
16 June 2020. Issued by the Secretary of Tourism, Government of Arunachal Pradesh by number so and so insofar as the petitioner is concerned. Petitioner and the respondent number 7. Huh? And the respondent number, not 7, 5.
Respondent
Are concerned. Where is 5 working now?
Same place, my lord. He's not, he's also not interested in.
Here was set as a request. Yes.
My lord, since the matter is being disposed, my lord, I thought we are on IA today. So my submission.
I also.
Yes, my lord. My submission praying for filing of additional affidavit may be kindly recorded, my lord.
No issue, Mr. Here, huh?
Because, my lord, even affidavit, counter affidavit is not with me, my lord. That is why. Because earlier.
Very good. You have not been provided with the counter affidavit by your department.
Because that was not filed even in my time. And today I thought that we are on IA, my lord. That is why I'm not even prepared.
In the beginning of the hard, though Mr. Father and Father Standing Council for the Tourism Department has prayed for adjournment of the case for filing of a additional affidavit on for filing of an additional affidavit, as well as on the ground that he does not have the copy of the counter affidavit filed, which counter affidavit filed by the Department of Tourism, which was filed by the earlier standing council.
Government advocate.
Okay, which was earlier filed by the government advocate, having regard to the nature of issue raised in this writ petition, this writ petition is taken up for disposal. Okay?
Yes.
Highly agree.
Apply.
He's saying there is I ask a question. Where is IA? In view of the. Yes. Okay, no abuse for the petitioner. What is the matter about?
Legal appointment.
Illegal
They are
appointment.
taking terminations to the illegal appointment.
Ah. Which post?
LDC, UDC,
Oh, that is appointed and terminated.
terminated.
It is against the termination order.
It's against the,
No.
it's against the appointment.
And the
And
appointment order.
subsequent to that lawsuit, some of them were terminated lawsuit.
Ah,
Then against the termination lawsuit matter came before this court, which was disposed of by a lawsuit,
ah,
which was dismissed.
okay.
Otherwise, lawsuit.
I think matter can be disposed of. No.
Parties.
Laji is representing the illegal appointee.
Respondent number 13 and 21.
Rama is also
Yes, 12 and 16.
12 and 16.
Yes, for it.
12 and 16. Laji is for 13 and
21.
13 and 21. Now, rest of the petitioner was terminated. They filed a writ petition, which has been disposed of.
This was dismissed.
That is, okay. Here, what is the private responsibility starts from 10, is not it?
Nine.
They-
Yes, okay.
No, 9 is deputy commissioner in person.
It starts from 7, but the so far.
No, no,
It starts from 12. Sorry.
Okay.
It starts from 11.
Yes,
Panyu.
yes, 11.
He was appointed with UDC.
11 to
11 to Losif
20,
23.
23.
Yes. From 11 to 23 Losif, all of them Losif they have been terminated. Against the termination date. Except for the respondent number Losif 12, 16 and 21.
12, 16 and 21.
21.
What about 13?
13 also not terminated.
Yes.
13 also?
Yes.
13 also not yet.
13 also has not been terminated.
4%.
Okay, they are still working.
Yes. Ma'am.
So we allow this writ petition.
No, my lord, the issue here was when grievance of that petitioner alleged that as per Arunachal Pradesh Staff Selection Board Act, that act has not been complied. Contention was there, and without following that act, the parties were appointed. So respondent authority here made inquiry. Those who were made appointment after the coming into force of the act, they have been terminated, my lord. And those who were appointed or promoted prior to the coming into the force of that act, my lord, they are continuing. And here all are not, my lord, direct appointee, my lord. Some of them are promoted, my lord.
Since petitioner side is also absent today,
So I'm also not prepared. Kindly matter may be posted for admission hearing. Since this is listed in order.
Let us see your appointment order. Your promotion order.
Page 43, my lord.
Page 43. How it is promotion? It is not a promotion. only.
It's not. Actually,
Okay.
this post
This
is a
is-
promotional post for those who are serving on LC and all.
See, your friends have gone. And that day, I still remember. The council was arguing. They have selectively terminated. Huh? Is not it? So it was, I think, M. Chanda.
Yes, ma'am.
Selectively terminated.
The hard
So,
one issue.
heartburning is there.
But the here, my lord, those are directly appointed.
And he is not challenging, okay, this is R21. Yes.
Yes, my lord.
You are representing, 13 and 21.
30 and 21, my lord.
Where is 13?
13. Page 51, my lord.
Page
51.
51. Page 51. Yes. Against the clear vacant post of LDC. No recruitment? No recruitment took place. Okay. And where is Thomas? Yours is 12 and 16. 12 is at 19.
12 and 16, man.
One is 53.
53 years.
Earlier case, it was not similarly situated. Therefore, this was segregated.
Let us see. This is also a direct appointment.
No, since she was serving since 2000. Oh, he was serving since 2000. Actually, today, my lord, I thought this is listed in orders.
No, serving is all right. It is a fresh appointment.
Page 53, my lord.
53.
He was serving as contingent staff in the DC office. And thereafter, Latron appointed to the post of LDC. And my lord, some recruitment rules, if my learned friend, senior government advocate can advise.
Respondent number 16.
16, my lord.
Page 45, I think.
45. Yes.
Now, my lord, prior to coming of this staff selection board, my lord, DC, they had been empowered with for appointment of LDC.
Was there any selection? Recruitment? No
This was, if record is available, we have to see the reply of the deputy commissioner. If it is done through the DPC, my lord, before coming up staff selection board, they had that authority, my lord.
My lord, one thing is here, my lord, though it's registered as a writ petition. And in the
Maintainability
body,
also we have raised
in the body they mention as a PIL. So whether it can be taken as a writ petition or a PIL. So we have raised the maintainability also, my lord. Because if it's a PIL, they have to, petitioner has to follow the guideline of our High Court rule. If it is a writ petition, my lord, then it has another, my lord, different.
It is a writ petition.
Yes, my lord. If my lord, this is treated as a writ petition, then petitioner himself has made that he is not agreed, personally agreed. And in such a case, my lord, those who are not agreed by the appointment, my lord, they cannot file a writ petition.
My lord, may I pray, my lord, for taking up the matter in some other day. Since we have raised the issue of maintainability, so maintainability also, so certain citation today which I have not brought also. If this is treated as writ petition also, my lord, the locus standi, my lord.
But why were your appointments not terminated along with others?
Because, my lord, reason is that basically this petitioner, that one Tanya Jun, his identity is at paragraph 1. He is saying that he is public spirited person. So accordingly, he filed RTI. From RTI, he got the information that such and such persons had been appointed. Whereas that is after coming to force of the Staff Selection Board Act. So therefore, considering his representation that went up to Chief Secretary, the case to case, it was segregated, is because those terminated persons, they had been directly appointed. And in the case of this poor person, my lord, they were contingent staff. And their forced, it was regularized. So if it has not done through the DPC also, my lord, there will be lapses of procedure, which this gentleman cannot question, my lord. Kindly see paragraph 1. He is saying that he is a citizen of India by birth, having his permanent residence at Linya village on the Paramputu administrative circle, Lower Sonsari, Arunachal Pradesh, and social activist against the corruption through organization so-called All Arunachal Volunteer Sena.
If they don't do, who else will do?
But then, my lord, if this is writ petition, at least he should have locus standi, my lord. If it is treated as PI,
Who is respondent number 2?
2 is, my lord,
Secretary personal,
Secretary?
personal department,
personal government.
This appointment was made by Deputy Commissioner.
deputy commissioner.
Deputy Commissioner has filed affidavit.
Also,
Also, everything was filed, everything on behalf of Mr. L. Chandra. But,
Respondent number
7
7. That is in person.
in person.
That is in person. Actually, official is
Fine.
4, respondent number 4.
already filed.
Already filed. Just a moment. Respondent number 4 has filed affidavit.
Yes, 4 and 5.
Let us see the affidavit for, oh yes, 4 and 5 is there.
Filed on 28 October 2020.
It is there. Which is the paragraph where you have explained in what manner?
Proceed for
We have not been furnished.
paragraph 7 was. Paragraph 9 was. And in respect of respondent number 11 also, kindly see the paragraph 8.
8.
8.
No, respondent number 11. Who is 11?
Proceed
We are concerned with only 4.
11, so sorry.
12, 13, 16 and 21.
You know, see the distinction between those who have been only terminated and these 4 persons are dead. These 4 persons, they were already engaged there also as a contingency also. Thereafter, and that was done, these appointments were done prior to coming of the APSSB also.
No, respondent number 13 was not a contingent employee.
One Likha Yarin was not.
He is a direct employee.
Correct. If you look at this present read petition, also, read petitions challenge their appointment on 2 counts. One is there was no selection process. Second is lordship, the deputy commissioner is not competent because APSSB was already constituted in the year 2018. Lordship. And so far the second lordship ground is concerned, that's APSSB is concerned. Here the answer of the authority is that this appointment of these 4 persons were done prior to coming of the APSSB. So far that issue is concerned, lordship, that has been answered. But so far the selection process duly it was followed or not, lordship. In that rigorous lordship, it seems it has not been properly followed, lordship. That is the lordship. And if lordship see the writ petition is pointed out by my friend's lordship. Here the case is not that lordship he want to participate in the selection process. This post should be advertised and he want to participate also. That is not the case here in the writ petition. So therefore the locus has been raised, and I too feel lordship when the petitioner himself is not interested, then he has, I think, no locus lordship.
No, see, that is all right.
So
We-
if
we
it's,
are- we
if
are-
it's treated as a PI lawsuit, then lawsuit definitely he has some say on the issue.
See, we are not against anybody.
No.
Here, respondent number 12, 16 and 21 may form one class. Other, different than those who were terminated, whose writ petition has been dismissed, is not it?
Oh.
But this respondent number 13 is definitely
Directly.
not, this is the same category of persons whose
Yes.
services were
But only,
terminated.
only distinction is
No, my
that
lord.
his appointment was made prior to APSSB.
That is hardly, that hardly any matter.
Lawsuit.
We hardly bother about this APSS.
Lawsuit.
See, even then, this appointment of 12, 16, 21 may not be justified in the manner it has been done. What is the matter of concern is, if you retain this, what effect it will have on the minds of the other respondents whose services have been terminated? This is the core issue. This
They
is the
can
ba-
always come
See-
before,
Huh?
they can always come before this honorable court if they are eligible for the post, my lord.
Who?
Those who have been terminated.
Who have been terminated?
Yes, my lord.
They will come only if the matter is put to advertise. You have been
No.
put there, Mr. Lazi.
My lord, they
See,
could.
see, 14 and 16, you can't run away.
Yes, my lord.
Huh? How, in whatsoever manner you want to employ technicalities, deploy technicalities, 14 and 16, you can't run away.
Yes, my lord. That's
Even
clear.
the parliament cannot tinker with this 14 and 16. Huh?
Yes, my lord.
How can you run away from that?
My lord,
But my lord, are we not diverting from the issues involved in this writ petition?
No, see, whether it is PL, not PL, when the matter has come to the notice of this court, we cannot shirk our responsibility from doing justice in the matter. Maintainable, not maintainable, you test it in the appeal.
now, if my lord,
See, if the authorities act in this manner, what the core issue is, what effect it will have on what effect it will leave on the minds of those whose services have been terminated. And this is the very core of the orderly existence.
my lord,
Everything originates from.
My lord, it's already in their knowledge, my lord. If any eligible person, my lord,
Yes.
any eligible person who is, my lord, aggrieved, they can always come before your before lordship, before this honorable court.
116B of RP Act 1951, my lord. With a limited prayer, my lord, since there is a provision to stay the operation of order that was passed by your lordship yesterday for a period of 30 days, so that at least we can, my lord, approach before the Honorable Apex Court to invoke our, my lord,
On what ground it can be stayed?
my lord, here it says 116B, my lord, an application may be made to the High Court for stay of operation of an order made by the High Court under section 98. Our falls under 98B, my lord, or section 99 before the expiration of the time allowed for appealing therefrom, and the High Court may, on sufficient cause, my lord, of course, being shown, and on such terms and conditions as it may think fit, stay the operation of the order, but no application for stay shall be made to the High Court after an appeal has been prepared to the Supreme Court.
What is the sufficient cause?
Sufficient cause, my lord, hearing. Since, my lord, this election petition, it was filed by the petitioner, praying for declaring him as returned candidate also, my lord, that has been declined by this honorable court. So balancing the thing, my lord,
What has been declined?
that the another prayer to declare the election petitioner as returned candidate
Yes.
has been declared. So had it been that was, my lord, allowed, then we would have not filed this application, because now situation will, my lord, that no one will be representing the people of Teju constituency, my lord, if this order is not stayed in the larger public interest. That is one count.
Then what will happen if it is not represented for a period of 1 month?
1 month, my lord, 1 month I am saying, because, my lord, we are not asking for absolute stay, my lord, just for 1 month that is provided in the provision of the act itself. So in this 1 month, my lord, there are so many works, projects that are pending. At least if this honorable court.
But what is the role of MLA there? It will be carried out by the district administration.
Other exercises.
See, MLA is not to be personally involved. He may have the supervision, etc., directions, but you can't give, you are not a part and parcel of the execution of the schemes or development works, etc.
And, my lord, if it is stayed also, my lord, this is not going to prejudice the election petitioner also, my lord.
Even project prepared by the MLA is executed by the district administration.
So
of course, at your behest.
That has to be followed up, my lord, because MLA is the concerned person.
See what? Yes. How such petitions, such applications are dealt with?
My lord,
normally it is stayed or
it is stayed, my lord, but with a limited.
After pronouncement of the judgment, my lord, it is a directory decree. It is effect forthwith, my lord, under section 107 of the RPI. And even this petition is not maintainable, my lord. Kindly see who has filed this application, my lord. This is by one Santosh Singh, power of attorney holder. This is the election petition, my lord. This is a part of election petition.
how can you find?
Yes, section 83
83.
is effect, my lord. Section 83 is said, my lord.
Order 3.
Person has to be signed, my lord.
This is not election petition, my lord.
Yes, it is a part of election petition. Shall be signed by the petitioner or verified by in the manner laid down in the civil procedure code for verification of the pleadings. Your pleadings have been verified By power of attorney holder, my lord. Even no ground has been stated, my lord. There has been a sufficient cause.
Ground is there.
Regarding, my lord, administration, what could be, my lord, look after by the administration. Administration is there.
So why should it be by power of attorney holder?
Pardon, my lord.
Why should it be by a power of attorney holder?
CPC order 3 rule 2.
Can one contest the election petition through a power of attorney holder?
No, my lord.
Then-
This is
then-
just for
then-
swearing affidavit, my
Swearing affidavit.
on behalf of the return candidate.
Then
Election petition, of course, my lord.
Election petition can also be.
No. Election petition, my lord, there are so many technicalities that has to be abided by. But then this is, my lord, IA.
Then where is the power of attorney?
Power of attorney.
You have to enclose the power, the special power of attorney.
Yes, we tried to enclose, but then registry has said that this will be not required.
Any precedent on what ground?
My lord,
see-
this
see-
morning only I have. Now my cross, my lord, one judgment. I have tried to search, but
See, this court have prima facie, this court have conclusively found that you have not been, you have been elected in breach of the law.
my lord,
Is not it? That's why your election has been declared void.
my lord.
And thereafter, this court again to state that very order. Just
Because my lord, statute provides for that, my lord.
provision is there.
My lord.
Sufficient cause. What is that
Sufficient-
sufficient cause?
Sufficient
Any-
cause, my lord, balance of convenience, like naturally, my lord, if there is no MLA, suppose,
Yes.
since your lordship has declared void, now there is no MLA in Teju. So the public will be stand still, my lord, if suppose anything has
For
to
a,
be-
for a period of 1 month.
for a period of 1 month, or even 10 days, my lord.
Without MLA, they can't exist.
They can exist, my lord, but then if suppose some ongoing projects that we have mentioned in our ground.
So you saw that which project, which is that project where without the participation of the MLA cannot be executed?
MLA is
You name any project.
in any district, my lord, for any developmental project, if suppose there is a meeting that is chaired by the concerned MLA.
But you have not brought on record.
That statement paragraph, of course, we have made. my
Nothing
lord.
is there, my lord, in the petition, my lord. Even
You
no
have,
sufficient
you
cause
have
was-
said, no,
One just.
not mentioned.
One judgment of, my lord. It's Allahabad High Court.
Because that sufficient cause, it is that I would like to know what is the sufficient cause.
We have mentioned it in paragraph 10. That your applicant says that there are certain ongoing public utility projects undertaken by the applicant as an MLA. And if the judgment and order dated 17/7/2023 is not stayed by additional court in excess of power under section 116B, all these projects will come to be halt and public interest would eventually suffer. So in that other case, my lord, they have said went to Honorable Apex Court. They have got the interim order from there. But then there is a provision, we can approach before this Honorable Court also.
But you have to show the
Sufficient cause.
But I don't find from the application filed by you is that
And other than that, my lord,
the people and administration of the Teju, 44 Teju Assembly constituency cannot be run smoothly without an MLA. Where is that? Where are those facts?
that is in paragraph 10, we have made.
Paragraph 10
Paragraph 10.
is not, it's all these projects. What are those projects? It is an omnibus statement.
Even this copies was not supplied to me properly, my lord.
Hmm?
This paragraph 10 and 11 is not in my petition.
10, 11,
Yesterday it was supplied.
paragraph 10, 11.
What my friend is saying is that one page is missing, but then this was received by one cutoff from filing section. And this is, it seems this is a printout copy of WhatsApp. So maybe, but then we have served the entire
Which
pages.
page? Which page is missing? Page 8.
He said page 8 is missing.
Page 8 contains only small 3 paragraphs, small 3 paragraphs. If you have a copy, you can furnish.
Oh, paragraph 10, my lord, administration is here, my lord, district administration.
All these projects will come
Yes.
to a halt and the public interest would eventually suffer.
And normally in such type of cases, my lord, we are not asking for absolute stay, my lord. Even in the CRPC, that provision is there. As and when conviction, then immediately suspending the sentence to enable the convictee to file appeal. The same provision has been enacted in this RP Act 1951. my lord. However, my lord, in all the judgments which I have searched, that is limited to that he cannot participate in voting, if any. Supreme Court, I found only one is judgment. Herein also so many things like balance of convenience, public interest that has been discussed. And this is your lordship that another case.
Will it be in the public interest that the people of a particular constituency for the period of 1 month is represented by a candidate who has been found by the High Court to have been elected in violation of the law, election law?
Of course, my
They
lord.
are also public interest.
Yes, because on that issue now we cannot say anything also
See.
since
As on that,
Ah.
your election stands void.
my lord.
Subject to the subject to the further order by the appellate court.
My lord.
Now the appellate court, whether appellate court would stay it or not, is also we don't know.
Of course, my lord.
So the statutory provision is this for the sufficient cause.
My lord.
It may be stayed for 30 days. Isn't
30
it?
days, my lord. So that sufficient cause
but-
also, my lord,
but-
our hardship will be, my lord.
What is that sufficient cause? The cause which you have said is that there are so many projects
That are initiated by this MLA.
which will come to a halt, but you have not specified the projects. What kind of a project? Jal Jeevan Mission
There are so many.
and
Jal Jeevan Mission.
if Jal Jeevan Mission, in Jal Jeevan Mission, we would like to see that without the participation of the MLA, the scheme cannot be executed. Then there may be a sufficient cause because the public will suffer for this period of 1 month. Is not it? So nothing is there.
Only paragraph 10.
So this is only how I understand is sufficient cause.
Sufficient cause, of course, it is
Sufficient
there.
cause means the constituency or the
Other than that, my lord, the sufficient cause would also imply, my lord, like
which one?
taking time in preparation of appeal, my lord. That will include the obtaining of certified copy.
Yes, which
Because-
one you want this court to look at? In the middle elections?
This 2 pages is of the
that is-
earlier one. They have straightway went to.
No, yes, you also go there.
So, no, my lord, we are approaching this before this oral court as because statutes provide so.
But you have to show the sufficient cause.
Sufficient cause is, my lord, that is the projects, my lord, that is well understood, my lord. If suppose since the election petitioner also not declared as return candidate in this election petition, my lord. So entire Teju constituency will be without the representative of member of legislative member, my lord. I mean, sorry, member in legislative assembly, my lord.
Yes.
Transfer, challenging the transfer order, my lord.
Oh, you have got a petition.
Yes, my lord.
This was mentioned today morning.
No, no, my lord. In fact, my lord, it was listed on 29/6, my lord. 29/6.
Okay.
Is and the interim was status quo was supposed to be maintained. As per the order dated 29/6/2023, my lord.
So why it has been listed today?
Because in the order itself, it was directed to be listed today, my lord.
Today?
Yes, my lord.
Okay, return 18/7.
Yes, my lord. He has appeared today only, my lord. I have served him the copy. And
You're for?
all the respondents.
All the respondents.
State Bank of India, my lord.
So what is to be done today?
Time may be given for filing of the affidavit.
Affidavit, okay. Had Mr. O. Prada, Islamic Council for the petitioner. And Mr. R.V. Other, standing counsel. Islamic Council for the, okay, just respondent. All three, huh? No. Who pressed for and is granted how much time? How much time? 4 weeks. 4 weeks. Who pressed for and is granted 4 weeks time to file counter affidavit. Listed after 4 weeks. Interim order pass earlier. They'll continue till the next data listing.
My lord. Obliged.
Yes, I'm well.
Yes.
This item will take some time, my lord.
What is the matter?
Matter, my lord, issue involved, my lord, is my lord, I have lost my lord, my only son, my lord, by in the police custody.
Custodial debt.
Custodial debt, my lord. Now, I am praying, my lord, some inquiry and compensation, my lord. So they have already filed everything, my lord, but I need to submit that to minutely, my lord. So it takes some time.
When do you want? What Mr. L. Prada, for the state. Let's put on the prayer council for the parties listed.
August.
In the month of August.
Yes.
Okay.
First week, my lord, first week,
First week of August. Okay, first week of August.
Does it mean second week?
Eight or late period, 8 mile, 8 mile, 8 August, mile.
8 August.
Yes, Lord.
Okay, 8 August.
I will.
All right.